Good afternoon. This is the clerk with Metro Court who just joined the call with the phone number ending in 3398.
Yeah, hello, that's me. My name's Andrew Kishman. I'm a court monitor with Mothers Against Drunk Driving.
Okay, you said Andrew Tishman.
Yeah, Kishman, Kishman.
Okay, thank you, sir.
Thank you.
Okay, good afternoon, everyone. Let's go on the record in State of New Mexico versus Ariana Montoya, T4DW 2020-1200.
Chris Richmond for the state.
Annalise Funk on behalf of Ariana Montoya, who is present via Zoom. And Ms. Montoya, if you would turn on your camera, please.
Okay. Okay, and while we wait for her to finish that, just as a threshold question, let me ask, Mr. Richmond, is the state ready to proceed to trial in this case?
Your Honor, I did not see Officer Herbst on the line, and that was, unless that was him that just called in with the number ending in 5425.
Okay, and is Officer Herbst on the line?
Your Honor, may I have one moment to try to call him just real quickly?
Sure, I saw he was checked in on officer check-in at 1:30.
All right,
So
okay.
I'll give you a minute to do that.
Thank you,
and
Your
that'll give Ms. Montoya a chance to figure out that camera. So I'll be back in about 2 minutes.
Officer Herbst, is this you who checked in under the name Albuquerque Police Issued Cell?
Yes, sir, it is.
All right, thank you.
Okay, parties, let's try once more. State of New Mexico versus Ariana Montoya, T4DW 2020-1200.
For the state.
Funk on behalf of Ariana Montoya, who is present. Ms. Montoya, did you figure out your Zoom yet? You're not on video. We need to see your face. And minimally, we need to hear you right now. So I know I told you to go on mute, but now you can unmute yourself, please. *6 well, I guess you're on Zoom. Ms. Montoya, we can neither see nor hear you. Ms. Montoya, maybe if you sign out and back in again, and make sure to press the option of keep your camera on. And Ms. Montoya, if you'll log out and then log back in using the same information I sent you, and make sure you're in front of a camera on whatever technology you're using.
Do you want me to take a break so you can give her a call and try and diagnose the issue?
Sure, I haven't been able to connect with her, but I will try. We'll see. We've been having some technological issues, but if you give me a minute or so, Your Honor, that would be helpful.
Yeah. Here, I'll log out. I'll just plan on taking the bench at let's say 2:15 to give you a chance to troubleshoot that tech issue.
Thank you.
And Nick, in the meantime, can you put me in a breakout room with Officer Herbst, please?
Yes, sir.
Thank you.
Ms. Montoya, can you now hear me? You're gonna need to unmute yourself.
Yes.
You have it resolved. So now put yourself back on mute.
Okay.
You need to
Okay.
be on video the whole time.
Okay.
Be mindful that you're in a place where there's no one present behind you, no distractions, and then keep yourself on mute until the court asks you to unmute, okay? But keep your video on. Thank you.
Okay, let's try once more. State of New Mexico versus Ariana Montoya, T4DW 2020-1200.
State.
And Elise Funk on behalf of Ariana Montoya, who is present via video conference.
Okay,
And
welcome. Good afternoon, everyone. Okay, and parties were set today for trial. There's also a probable cause motion to hear first. And just as a matter of clarity, state you had filed the amendment for specific charges for driving under the influence first offense and an open container first offense. Are those the two charges you're proceeding with today?
Yes, Your Honor.
Okay, and how many witnesses will you be calling today?
Just Officer Herbst, Your Honor.
Yes, Officer Herbst. Okay. All right, and so parties, there are some pretrial motions to address. So Officer Herbst, I can either put you in a waiting room or the DA could just give you a call when it's your turn to testify. How would you like to handle that on your end?
A call would be best, please.
Okay, and Mr. Richmond, do you have Officer Herbst's number?
Yes, Your Honor.
Great. Okay, so Officer Herbst, you can go ahead and hang up. The DA will give you a call when it's your turn to testify.
Great, thank you.
Great. Okay, and so parties, let's talk about the exhibits and the motion in limine. The state submitted its proffered exhibits number 1 and number 2. And then the defense motion in limine was more specific about state's exhibit 1 with the time notation 7:42 through 9:04. And so defense, since you're the moving party there, I'll start with you, Ms. Funk.
Yes, Your Honor. The timestamp that defense seeks to exclude is the duration of the HGN test. And if you look at State versus Torres and you read the entirety of the case, you'll see that the court was very specific in its holdings and held 3 different times in that same decision that the only way an officer can testify about it, the only way HGN evidence makes it into the trial at all, is if the state first called a scientific expert to first establish the evidentiary reliability of the scientific principles. And so, Your Honor, if you look at State versus Torres, 1999, NMSC 010, paragraph first 46. In paragraph 46, we see the court say, we conclude that such non-scientific experts may testify, provided that another scientific expert first establishes the evidentiary reliability of the scientific principles underlying the test. This is a clear if then. This is a clear first and second. The state first has to meet the expert burden before it can admit any HGN non-scientific testimony. And then if you go down to paragraph 47, the court reemphasizes that officers may testify as to the administration and specific results of the test after it has been shown to meet the requirements of evidentiary reliability. Again, the court emphasizes the same point, that the state's burden is first to introduce expert testimony about the reliability of the HGN test before any other HGN testimony or evidence can be admitted. And if you look then on paragraph 54, the court emphasizes a third time, really bringing home this point. It says that if, the clear if is really important here, if then, right? If, after considering these factors on remand, the trial court determines that the state has satisfied its burden of establishing the evidentiary reliability of the HGN test, then Officer Bowditch may testify about his administration of the HGN test. It could not be more clear in Torres. If the satisfaction of the evidentiary reliability, then the officer testimony. And so because a clear reading of Torres shows that the court took pains to emphasize this point, we would ask that the entire HGN evidence in the video and also testimony be excluded because there's no expert witness on the witness list that could testify and lay the scientific foundation. Additionally, Your Honor, it's not in the written form, but we would actually move to exclude ahead of time any mention of a Smirnoff bottle on the best evidence rule. So according to Rule 11-1001, a writing consists of letters, words, numbers, or their equivalent set down in any form. So the bottle alleged in this case that has a name on it, that is considered a writing by Rule 11. And for this writing, the original or a duplicate is required to prove what that label said under Rule 11, 1002. And duplicates would be admissible here, but the state has not offered any on its exhibit list. And so we would ask to exclude any reference or statements that the bottle said Smirnoff, or that the bottle was a Smirnoff bottle, as that is a writing. Thank you.
Thank you, counsel. Mr. Richmond, any response?
Yes, Your Honor, just in regards to the HGN section of defense's argument, Your Honor, the state isn't going to be offering eye movement, and Lasworth and Torres says that the state cannot use the eye movement. So that's my response to that. And regarding the defense's just mentioned regarding the Smirnoff bottle, Your Honor, the best evidence rules applies to writings, photographs, and recordings, and to introduce the truth of those matters. And Your Honor, the Smirnoff bottle, it's a bottle, it's not a writing, recording, or a or photograph. And any observation of the officer of such a bottle would just be a permissible lay testimony. Thank you.
Thank you. Okay, Ms. Funk, any reply?
Yes, I would note that we're not seeking to exclude the bottle. We're seeking to exclude the testimony about a label. The label on the bottle that says Smirnoff, allegedly. We need to exclude that because it is a writing, according to the clear definition. And so by the best evidence rule, we would seek to exclude any testimony as to what kind of bottle it was.
Okay. So parties, here's our rule. On the motions in limine regarding the horizontal gaze nystagmus test, Lasworth and Torres are correct in that any testimony about eye movements is excluded that will not be admitted into trial. However, that the motion in limine is asking to exclude about 1.5 minutes when the officer performs. Because the officers make other observations during that period of time, eye movement really isn't visible on those things. It won't be considered. I'm going to deny the motion to exclude those things, as my ruling on Lasworth and Torres is that testimony about the horizontal gaze nystagmus will be excluded, but that doesn't mean that this 1.5 minutes should be excluded. So that motion will be denied. Regarding the label on the Smirnoff bottle, defense has argued that the best evidence rule applies. I agree with the state. The best evidence rule does not apply to this case. The officer can testify about the bottle that he observed and any writing on that bottle. Okay. And so with that, are there any other motions in limine to address?
None from the state, Your Honor.
And none from defense.
Okay, so states exhibits 1 and 2 are not admitted into evidence. The state will still need to lay foundation for those things during the trial. Now, parties, there was a probable cause motion filed long before any of us in this room were on the case. But I didn't see anything about withdrawing that. So I assume we're still moving ahead with that. Is that right, parties?
That was my anticipation, Your Honor.
Correct, Your Honor.
Okay, and so parties, my traditional practice when we have a motion like a probable cause motion is that I'll hear that probable cause motion first. The rules of evidence will apply during that motion hearing. And if I deny the defendant's motion to suppress due to lack of probable cause, then I'll just incorporate the testimony into the trial. Any objection to that, parties?
None from the state, Your Honor.
None from defense.
Okay, and so with that, for purposes of the motion hearing, defense is the moving party. Let me start with you, Ms. Funk. Is there any opening statement regarding the probable cause motion?
Yes, Your Honor, one moment.
Yes, Your Honor. Logan Wexler on behalf of Ms. Montoya. Are y'all able to hear me?
Yep.
Yep.
All right. So in this case, we moved to suppress for lack of probable cause. And just to briefly touch on what the evidence you're about to see is going to look like. Ms. Montoya has anxiety, depression, and PTSD, and it is severe. It's severe to the extent that her doctor has decided to prescribe her with medication. And this is something that you'll see that she told Officer Herbst very early on in the traffic stop. She told him that she's had a really bad last few days. She told him that it was bad enough that she was on medical leave from work because of it. But instead of taking that into account in his investigation, he just blew right past it. He turns every question that she has, every clarifying question, into an opportunity to argue with her. He'll testify to watery eyes, and you'll see on the video that that's not the case. He'll testify that she started the one-leg stand too early. And then in the video, it'll clearly show that she's just trying to clarify the instructions with him, and she's not starting too early. He'll testify that she swayed during the one-leg stand, and then the video won't show that either. He'll claim that he's trained in NHTSA, and then in the video, you'll see that he doesn't follow it. He doesn't take into account height, weight, proportionality. He notes down clues that are not standardized clues. And the NHTSA manual implores officers 6 times to make sure that their administration of the test is standardized and that they only look for standardized clues. And then you'll see that the other factors that are present in a DWI where someone's impaired, those aren't going to be there either. She doesn't slur. She talks really clearly. She looks perfectly normal getting out of the car, doesn't stumble or lean. Then you'll hear him say that he believes that she's under the influence, but since he knows he lacks probable cause, he'll offer her a PBT. And then when she doesn't accept it quick enough, he'll deny her the right to take it in the end. He said, no, you didn't say yes at first, you lost that chance. Basically, you will see him decide that since she was supposedly driving bad and that he smelled something, it might have been perfume, might have been alcohol, I'm not sure, that he's going to find enough clues to arrest her. And instead of taking on the totality of the circumstances, he's just going to go through the motions, check as many boxes he can think of, and then arrest her without probable cause. And we think that the evidence that Your Honor is about to see is going to show that.
Thank you, counsel. And Mr. Richmond, does the state have any opening?
Yes, just briefly, Your Honor. The evidence that the state will be presenting will consist of Officer Herbst on his testimony and his lapel video, as well as the defendant's statements. After listening to these items, the state does request that the court pay attention to the evidence that is presented and the evidence that is present, not what is not present. And the state does respectfully request that this court find there was probable cause for the arrest. Thank you.
Okay, thank you. And now, since the burden shifts to the state to prove that it was a lawful arrest, Mr. Richmond, please call your first witness.
All right, thank you, Your Honor. Give me 1 second so I can give him a call to hop back on.
Okay, and welcome back, Officer Herbst. I'm going to go ahead and swear you in for your testimony. Will you please raise your right hand? Do you swear and affirm that the testimony you give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Okay, with that, Mr. Richmond, your witness for direct examination.
Good afternoon, officer. Can you state your name for the record?
My name is Zachary Herbst.
And how are you employed?
I'm a full-time sworn salaried commissioned peace officer with the Albuquerque Police Department.
And were you on duty on August 14th of 2020 around 8:15 p.m.?
Yes, I was.
And what were your duties on that date?
To conduct traffic stops, respond to crashes, and respond to any scene where there was possibly a driver who was possibly under the influence.
And what were you wearing?
I was wearing a full police uniform, displaying my badge of office.
And what were you driving?
A marked police patrol vehicle.
And did you contact anyone on that date of incident that you see over Zoom today?
All right, give me a sec. I gotta scroll through here. Okay, yes, I did.
And can you describe what that individual was wearing?
She has on, looks like reading glasses and looks like a gray low cut shirt on.
And Your Honor, may the record reflect that Officer Herbst has identified the defendant?
It will so reflect.
And Officer, where did you contact the defendant?
Well, I saw her driving on Montgomery, and I first contacted her near the Chipotle, which is at Montgomery and San Mateo, which is all that is city of Albuquerque, county of Bernalillo, state of New Mexico.
And how did the defendant get your attention?
So I was driving east on Montano approaching I-25, and I was in the center lane, and the speed limit there is 45 miles per hour, and it is marked. And what caught my attention was there was a black Nissan in the far right lane, and it passed me. I couldn't get a speed on it, but it was at a pretty high rate of speed. It was definitely more than 45 miles an hour, which is what I was traveling. And eventually caught up to the vehicle at around Carlisle because of a red light. And when the light turned green, that Nissan accelerated rapidly again and began swerving in and out of lanes and tailgated at least two cars. And when I say tailgated, it was within one vehicle's distance from the vehicle in front of it. And right at that point, the speed changed to 35 miles per hour, and it is marked as such. And the vehicle continued to swerve in and out of several lanes, eventually swerved over to the left lane, and there was no traffic in that lane, and really took off from that pack of vehicles. And I tried to keep up with the vehicle, and I saw, based on my speedometer and my Garmin GPS in my vehicle, that I was traveling 60 miles per hour. And that Garmin calculates my speed by satellite. So I was traveling 60 miles per hour, and that Nissan was still increasing its distance from me. So I didn't get an exact speed, but it had to have been traveling more than 60 miles per hour in a 35 mile per hour zone. And it eventually had to slow down due to some other traffic. And that's when I caught up to it, almost to Montgomery, and put on my lights and sirens and conducted a traffic stop on the vehicle.
And prior to using your radar to determine the defendant was going about 60, did you use your radar at any point prior to that?
No, I actually didn't use radar at all. I based that 60 miles an hour based on my own speed, based on the Garmin GPS and my speedometer. I look at both. And I saw I was traveling 60 miles per hour, and that Nissan was increasing its distance from me. So that meant it had to have been going greater than 60 miles per hour, but I didn't get an exact speed.
Thank you, officer. And how fast, or what did the defendant think the speed limit was?
Objection, as the defendant thought.
Yeah, so there's a speculation objection, and that'll be sustained.
All right, I'll rephrase.
Mr. Richmond, please ask a new question.
And Officer Herbst, what did the defendant tell you was the speed limit?
So Miss Montoya was driving the vehicle, and she told me she thought it was 45 miles per hour.
And even if that was the speed limit, would the defendant have been going that speed limit?
No.
Did the defendant say why she tailgated the other cars?
I don't think I think she's thought that she wasn't tailgating the vehicles, actually, I think is what she said.
And after you were able to catch up to the defendant, what happened next?
So when I caught up to her, put on lights and sirens, conducted a traffic stop on the Nissan, and it pulled over, and Miss Montoya was the driver and sole occupant of the vehicle. And I told her why I pulled her over, that she was driving very poorly and speeding, and asked for a driver's license, registration, insurance.
And were you wearing a mask on this date?
Yes, I was.
And upon your contact with the defendant, did you make any observations?
Yes, her eyes were bloodshot watery, and I smelled a very strong odor. It was a very fruity odor. I thought it would would be like perfume or lotion. And also mixed in with that odor was a moderate odor of alcohol emitting from her facial area.
And did the defendant say if she drank any alcohol on that date?
No, she said she hadn't drank any alcohol recently.
Did the defendant say when she had last consumed any alcohol?
She did, and it was either days or weeks ago is what she told me.
And did the defendant say if she took any medications on that date?
Yes, she said she is prescribed some type of medication. It's either anti-anxiety or antidepressant medication, but she couldn't remember the generic name for it.
And did she say if this was a new medication or if it was one that she normally took?
I don't recall, but I just recall that she remembered that she told me it was prescribed to her.
Okay.
And
And
and I'm sorry, she took it at 7 p.m. was what she told me.
And did the defendant ever try to look up the name of that medication?
Yes, she did, and she was not able to find it.
Do you recall any issues she had with her phone when she was trying to look it up?
I don't recall any issues with her phone.
And did the defendant stay in her car throughout the entire interaction?
No, I did ask her to exit the vehicle so she could perform standardized field sobriety tests.
And once she was outside of her car, did you make any additional observations of her?
I just continue to smell the odor of alcohol emitting from her facial area.
And was it still the moderate odor that you smelled prior?
Yeah, it stayed pretty consistent throughout. I'd say maybe a little stronger because the odor of that fruity odor died down.
And did that odor, was it present throughout your entire investigation, or was it just then?
The fruity odor or the alcohol?
The odor of alcohol.
Yes, the odor of alcohol stayed present throughout.
All right. And then what was the next step in your investigation?
I asked her if she'd be willing to perform standardized field sobriety tests based on the odor of alcohol and her bloodshot watery eyes,
Yeah.
and her admission to taking some type of prescription medication.
And actually, let's go back to that real quick. Did she say what it was a generic prescription of?
No, she couldn't remember the generic name of the prescription.
Okay. And did the defendant agree to take the standardized field sobriety test?
Yes, she did.
And what's the purpose of field sobriety tests?
Field sobriety tests are divided attention tests used by officers in the field to determine if someone is impaired due to intoxicating liquor and or drugs, or if they're safe to operate a motor vehicle.
And how does the divided attention test relate to driving?
Well, with driving, the driver is required to perform multiple tasks simultaneously, such as steering, braking, turn signals, paying attention to other vehicles, speed limit, things like that, all simultaneously. And in the field sobriety test, the person performing the tests are asked to perform multiple tasks simultaneously, and alcohol and drugs can affect one's ability to perform multiple tasks simultaneously.
And what training do you have in DWI investigation?
Up until that point, I had undergone the 40-hour DWI block in the academy, which included a wet lab. I'd undergone advanced roadside impairment driving course. That's a 16-hour course. Standardized field sobriety instructor course, which is a 40-hour course. And I was up to date with all my biannual training.
And can you explain what a wet lab is?
A wet lab, it was in the academy. It was when the APD staff, sworn police officers and DWI police officers brought in citizens to the academy and dosed some of them with alcohol of varying degrees, some no alcohol at all. And it was up to my job at the time to have them perform standardized field sobriety tests and make a determination if they were impaired due to alcohol.
And were you correctly able to identify the participants who had drank and those who had not drank?
Yes.
And the ones withdrawn. And were you supervised during that wet lab?
Yes, I was.
And I know you rattled off all the items that you have in DWI training, but just to be explicit for the court, were you certified in field sobriety testing on the date of incident?
Yes, I was.
And about how many DWI investigations have you performed?
I would say over 500.
And in those 500 investigations, have you arrested all 500 individuals?
No,
Why not?
not everybody was impaired due to intoxicating liquor and/or drugs.
And before these tests, did the defendant have any medical conditions that would impair her ability to perform the test?
No, none that would impair her ability to perform the test. I asked her about any medical conditions, injuries, or limitations, and what she told me was PTSD and anxiety, but it didn't seem like it would affect her ability to perform the SFSTs, and she never made any indication that it would affect her ability to perform the tests.
And did you notice a limp or any other type of physical impairment that would impact the test?
No, I did not.
Do you recall what type of shoes the defendant was wearing?
I don't, but she actually took off. I gave her the option of taking off her shoes for the test. So for the test, she actually had just socks on.
Can you describe the location of where the field sobriety tests were conducted?
They were conducted. It's a Domino's, behind the Domino's, which is right around San Mateo, Montgomery, and they're all conducted on the, I believe it was on the sidewalk or the parking lot area. So flat hard surface.
And what was the condition of the sidewalk?
It was flat, hard, paved, free of debris.
And what was the first test that you administered?
The first test was a horizontal gaze and nystagmus test.
And what instructions did you give for that test?
I asked her to stand with her toes and heels together, her hands and arms at her sides, and to follow the tip of my finger with her eyes and just her eyes and not move her head at all.
And are those the,
We would just object to any HGN testimony and preserve that.
Okay, your ongoing objection will be noted, and I'll note that my previous ruling was that any reference to eye movement is excluded, but your ongoing objection to this entire section is noted. Mr. Richmond, please proceed.
are those the same instructions that you always use for this test?
Yes.
Did the defendant understand those instructions?
Yes.
Objection as to what the defendant understood.
Okay, an objection to speculation, Mr. Richmond.
It's whether the defendant understood the instructions and based on the interaction with the officer.
Okay, based on the phrasing of the question, I'm going to sustain. You can rephrase to ask that.
All right, thank you. And officer, did the defendant say whether she understood the instructions?
Yes, she said she did.
And without reference to eye movement, was the defendant able to follow those instructions?
Yes, she was.
And what was the second test?
Second test was a walk and turn test.
What instructions did you give for that test?
So using an imaginary line, I asked the defendant to put her left foot on the line, right foot in front, toe touching heel. I asked her to put her hands and arms at her sides and to stay in that position while I demonstrated the test. And I told her, when I tell you to begin, I want you to take 9 heel to toe steps going down on the line. Once you get to your 9th step, leave your front foot on the ground, take a series of steps, turning yourself around, and take 9 heel to toe steps going back on the line. During the test, I asked her to keep her hands and arms at her sides. They were touching her sides the entire time, look down at her feet the entire time, count each step out loud, and to not stop until she finished the test. And then I demonstrated the test for her by doing those exact things. I took 3 steps down and 3 steps back. And yeah, those are the instructions I gave her.
And when this test is given, when the defendant is to, or the suspect is to imagine or to have an imaginary line, are those the same instructions you always give?
Yes.
And did the defendant say if she understood those instructions?
Yes, she did.
What clues do you look for on this test?
During the instruction phase, I check to see if they lose their balance by their feet breaking apart, if they start too soon. During the walking phase, I check to see if they miss heel to toe by 1/2 inch or more, if they raise 1 or more arms 6 inches or more from their sides, if they step off the line, they take the correct number of steps, if they stop, and if they perform a correct turn.
And what do clues indicate?
Clues indicate impairment.
And were any of those clues present when the defendant performed this test?
Yes, 2 of them were.
And which ones?
Her arms were more than 6 inches from her sides the entire time. Both hands and arms were. And then for the turn, when she got to her 9th step, she didn't take a series of steps. She just took a 180-degree turn, which was not how I explained and demonstrated for her. So 2 out of 8 clues on that test.
And what was the next test?
Next test was a stand.
And what directions did you give for that test?
I asked her to stand with her toes and heels together, hands and arms at her sides, and to stay in that position while I explain and demonstrate the test. And I told her, when I tell you to begin, lift up 1 foot, your choice, right or left. Lift that foot 6 inches off the ground. Keep both of your legs straight. Keep your hands and arms at your sides, so they're touching your sides the entire time. The elevated foot that you lift up, point your toe forward, so the bottom of your foot's parallel to the ground. Look at that elevated foot and count out loud. 1001, 1002, 1003. Keep counting that manner until I tell you to stop. And I did demonstrate that test for her.
And are those the same instructions you always use?
Yes,
Did the defendant say if she understood those instructions?
she said she did.
Did the defendant have any questions?
She did have a question about how high 6 inches was.
And were you able to answer that question?
Yes, and I gave her a visual with my finger, my thumb to my pinky. When I stretched those fingers out, is about 6 inches. And I also said a Coke can is about 6 inches as well.
And did you demonstrate, or did you give a demonstration of this test?
Yes, I did.
And what clues do you look for on the 1-leg stand?
See if she put her foot down anytime, she swayed, she raised 1 or more arms at least 6 inches from her sides, and if she hopped.
And were any of those present?
Yes, she put her foot down 1 time. Both of her hands and arms were more than 6 inches from her sides the entire time, and she also swayed on 2 separate occasions.
And did the defendant start when she was instructed to?
She actually started early, and I'd remind her to not start.
And after the 1-leg stand, were any more tests offered to the defendant?
I did offer her the opportunity to provide a breath sample into a preliminary breath test.
And why did you offer a PBT or a preliminary breath test?
Well, at that point, I did believe she was impaired due to intoxicating liquor and or drugs, but I did offer her the test to see if that impairment was more due to the alcohol or due to the prescription medication that she had taken.
And did the defendant agree to take that test?
No, she did not.
And did she make any statements when asked if she wanted to take that test?
She made some statements. I can't remember her wording exactly, but it was pretty clear to me that she did not want to provide a breath sample into the PBT.
Okay. And at this point, what opinion did you form about the defendant's ability to safely drive?
Even prior to the PBT, I did believe that she was impaired due to intoxicating liquor and or drugs.
And what did you form that basis or that opinion on?
That was based on the very poor driving, odor of alcohol, bloodshot, watery eyes, admission to taking prescription medication, and then the performance on the field sobriety tests.
So do those items include all your observations?
Yes, I think that was everything.
Mm-hmm. And what did you do next?
I placed her under arrest for DWI.
As the defendant was being placed under arrest, did she say anything regarding the preliminary breath test?
Yeah, she said around the time that she actually did want to take it, but at that point, I believe it was too late and would be like a coercion type issue.
And did she say why, now that she was being placed under arrest, she wanted to take the preliminary breath test?
I don't remember her exact wording on that.
Okay. And Your Honor, may I play a few seconds from State's Exhibit 1 in order for Officer Herbst to authenticate it?
Okay, go ahead.
All right, give me 1 second to get that. And Officer Herbst, do you see my screen?
Yes, I do.
All right. And Officer Herbst, do you recognize what you're seeing on the screen right now?
Yes, that does appear to be my a recording from my on-body recording device, and it is the date in question. I can see that, and it does appear to be my video from the date in question.
And how do you know it is your video?
Well, I can see that looks like a black sedan, and that's what type of vehicle it was. I can tell by the location. That was my vehicle that I got out of, and the date as well, and as well as just the date. So it does appear to be my video.
Mm-hmm. And is this video in the same or the substantially same condition as it was on the date of incident?
It would appear so. It's 45 minutes, which I believe was about the right time.
Right. And Your Honor, the state moves to admit State's Exhibit 1 into evidence.
Okay, and defense.
Nothing from defense.
Okay. State's Exhibit 1 will be admitted into evidence.
Right, Your Honor, and would you like the timestamps that I plan on playing?
Sure.
I will be playing up to the 5-minute mark, and then from 5 minutes and 33 seconds to 16 minutes and 7 seconds.
Okay, thank you.
Hello, Prince Barner. Why are you driving so poorly? You're going at least 60 miles an hour, and you tailgated 2 separate cars.
Oh yeah, no, I didn't know I was going that fast at all.
You didn't see all those cars you passed at a very high rate of speed? I mean,
No,
even they were
I was going
speeding.
the speed limit.
The speed limit's 35.
I was going 45.
It's 35. I was going 60, and you were increasing your distance from
I
me.
thought it was 45, so I apologize.
Well, how come
I
you're
thought it was
tailgating other cars so much?
I'm not trying to tailgate. They're just slowing down.
Well, those ones that you're tailgating were driving the speed limit.
No, I thought I was driving the speed limit, 45. So I apologize.
So that's just usually how you drive?
No, I'm just trying to get where I'm going. That's all.
Can I see your driver's license, registration, insurance, please? Have you had anything to drink tonight? So is it a rental car?
Yes, it is.
Okay, I'm gonna give this back to you.
Okay.
Let me check your eyes just to make sure you have anything to drink, okay? What you do is take your seatbelt off and turn your whole body towards me, okay? So what I want you to do is put your right hand here, and left hand here, lean forward towards me. The tip of my finger here, follow with your eyes, just your eyes, don't move your head, okay?
Okay.
Alright, you can relax. When was the last time you had anything to drink?
Yesterday,
Have you done any prescription medication today?
I do take a prescription medication.
What do you take?
I don't know the generic name of it. I can look it up on my prescription
What is it for?
for depression and anxiety.
Do you have any idea what it's called?
The generic name, I don't know what it's called.
Okay, what's the one that you take?
That's what I take, the generic one. I don't know the name of it, but I can look it up for you.
Okay, sure. Go ahead, do it.
Sorry, I quite dropped my phone. Sorry.
You take that medicine today?
Yes, I did take it today.
Is it prescribed to you?
Yes, it is prescribed. Absolutely.
Does it say anything about driving on it, that you're not supposed to drive when you take it? What time did you take it at?
About 7:30, 7:45.
AM or PM?
Yeah. Can I, my battery's at 5%. Can I? And I apologize. I've just had a really bad day.
Do you have any medical conditions or injuries or limitations?
Just my depression and anxiety and PTSD. I do have medication prescriptions for. I'm
And
even
you said
on
it's for depression?
and anxiety and PTSD. Yes, sir. I'm
And
even
how-
on.
how
I'm
many
even on
types
a
did you-
medical leave of work because of it.
How many different types of prescription medication do you take today?
Just the one. Just the one. But I don't. It's new to me. I don't usually take it. But because of a lot of things that have been going on with me the last few days, I did take it today. I've just been on high anxiety. That's all. I'm sorry. I'm just trying to.
You don't remember your password?
No, I do remember my password. I do remember. It's just my user ID because, like I said, I don't usually sign in like this.
Okay, well that's fine. That's fine. Let me do this. Let me have you step out so you can do a couple tests so I can make sure you're safe to drive. Okay.
Do you want me to leave the car?
No, go ahead and take the keys out. Turn it off and take the keys with you.
It's just this thing.
Okay. Do you have any contacts in?
Yes, I do have contacts. And they're really old. You want me to hold these?
Yeah.
Or?
Yeah. Do you have pockets?
No, I don't have pockets.
You can just put them right back there. Okay, just stand right there with my lighters, okay? I'm gonna check your eyes first, okay? So what I want you to do is put your toes together and heels together, like mine, and hands it onto your sides, so they're touching your sides, just like that, okay? So you see the tip of my finger? I want you to follow with your eyes and just your eyes, and don't move your head at all, okay?
Okay.
Keep following it till I tell you to stop. Okay. Do you have any questions?
No.
Do you understand?
Yes.
How do you feel walking in those shoes?
I feel fine. I mean, they're pretty brand new, so.
Well, we're gonna do a walking test next, so it's up to you if you wanna take them off or leave them on. Okay. Which one do you like to do?
I think I'm fine.
Fine, leave it on? Okay, let's come over here to the sidewalk where it's nice and flat. Alright, so go ahead and face this way for me. Okay, just stop right there. So what I want you to do is imagine a straight line running right down the middle of the sidewalk, okay?
Okay.
Imagine that line about as wide as your foot. Okay, what I want you to do is put your left foot on the line and your right foot directly in front of it.
Okay.
So the toes touching the heel.
Okay.
Go ahead and do that for me. So I need you to put your right foot in front of your left.
Sorry.
So the toes touching your heel. Now put your hands and arms at your sides so they're touching your sides. Just like that. Okay, I'm going to explain and demonstrate this test, but I want you to stay in that position. Don't move until I tell you to. Do you understand?
Yeah, sorry, my toes are a little squished. Sorry.
From what?
From my shoes.
Do you want to take them off?
Yeah, I kind of do.
Oh, that's fine. You can take them off.
Sorry, I'm just not
That's fine.
see how tight care I'm with. Okay.
All right, so left foot on the line and right foot directly in front of it. So toes touching the heel. Just like that, hands and arms at your sides. Okay, I'm gonna explain and demonstrate the test. Don't, once you get set. Okay, just like that. Don't move from that position until I tell you to. Do you understand?
Yes.
Okay, when I tell you to begin, you're gonna take 9 heel to toe steps going down on the imaginary line.
Okay.
You're gonna do a turn. I'll describe the turn here in a second. And then you're gonna take 9 heel to toe steps going back on the imaginary line.
Okay.
Okay, heel to toe means at each step, the heel of one foot touches the toe of the other.
Okay.
During the test, I want you to look down at your feet the entire time, count each step out loud, and make sure your hands and arms are touching your sides the entire time like they are now.
Okay.
Okay, so watch me. I'm going to demonstrate. I'm going to go this way, but when you do it, I want you to stay on the line, okay? Okay, so when I tell you to begin, it's going to look like this. 1, 2, 3. I took 3 steps, but you're going to go all the way to 9.
Okay.
Once you get to your 9th step, leave your front foot on the ground. Take a series of steps, turning yourself around, and you're going to come back on that same line. 1, 2, 3. Again, I took 3 steps, but you're going to go all the way to 9.
Okay.
Once you start the test, do not stop until you finish the test.
Okay.
Do you have any questions about the test?
No.
Do you understand the test?
Yes.
All right, ma'am, go ahead and begin.
1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay, you can stop. You can stop. Go ahead and face me.
Sorry.
All right. For this next test, what I want you to do is put your toes together and heels here like you are now. That's fine. And then put your hands around your sides. Okay, I'm going to explain this test, but don't move from that position until I tell you to. Okay? All right, when I tell you to begin, I want you to lift up 1 foot off the ground. Your choice, right or left. Lift that foot 6 inches off the ground. That's about the height of a Coke can. I want you to keep your both legs straight. Hands and arms at your sides the entire time. Look down at your foot that's elevated and count out loud. 1001, 1002, 1003, and you'll keep counting that manner until I tell you to stop. Okay, so watch me. It'll look like this. 1001, 1002, 1003, and you'll keep counting that manner until I tell you to stop. Notice how both of my legs are straight and my toes pointed forward. Okay, so make sure you point your toe forward so the bottom of your foot's parallel to the ground. Do you have any questions about that test?
Can I make sure I'm like this?
Hold on, let's start again. So,
Sorry.
so what you just did right there wasn't 6 inches, okay? It's got to be
Okay.
a little bit more.
No, I just want to make sure I have the right height.
Yeah, so 6 inches is about the height of a Coke can, okay? So hold on. Do you have any questions about that test?
Well, no, I just want to make sure I'm 6 inches high up, like a Coke can.
Okay, well, yeah, it's about that height. Right here. Okay? Do you have any questions about the test?
You want me to keep saying 1000, 1002, you tell me to stop.
Yeah, 1001, 1002, 1003, and then just keep counting in that manner, in that sequential manner until I tell you to stop. All right, any other questions? Do you understand the test? Okay, ma'am, go ahead and begin.
1, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 1009, 1010, 2011, 2012, 2013, 2014, 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025.
All right, ma'am, you can stop.
I'm not very strong legs, sorry.
So I have in my car what's called a preliminary breath test. It measures your breath alcohol concentration. Would you be willing to blow into that so I can measure your breath alcohol concentration?
I mean, if what we've done so far and you still feel that you need to,
Yeah,
I mean,
well, I don't.
I'm almost to my
So
destination.
this is where I'm at right now.
Okay.
Based on your driving, how you did on those tests, I don't think you're safe to drive. Okay, you said you haven't had any alcohol. I just want to rule out alcohol.
Right, since yesterday.
Okay, so would you be willing to blow into that preliminary breath test?
Yeah, I mean,
I can't force you to do it.
I really don't feel it's necessary, but I mean, if you feel that somebody could come get my car and me not drive, I'm okay with that, because I just took my medication. I've been on high anxiety. I have not.
Well, at the end of the day, I need a yes, you would. Yes, you will blow into it, or no, you will not.
I mean, no, I don't feel that it's necessary.
Okay, if you don't want to blow into it, that's fine. I can't force you to do it, okay?
Right, I mean.
Okay, so what I'm gonna do is place you under arrest for driving under the influence of intoxicating liquor or drugs, okay?
Okay.
So what I need you to do is go ahead and face away from me and put your hands behind your back. You're under arrest.
So can I still blow into it?
No, that's over and done with. You lost that chance, okay?
But I don't.
So go ahead and face away from me and put your hands behind your back. Thank you. Hands behind your back.
All right, and officer, I just have a few follow-up questions. Give me 1 second to get it resituated.
Sorry.
Just give me 1 second. Let me get my screen resituated. 1 second, please. All right. And now, after seeing that lapel video, do you recall when the defendant said she took that new medication?
7:45, I believe is what she said.
And do you recall if the defendant had any issues with her phone when looking it up? The
Yeah,
medication?
she said he had 5% left.
Was the defendant able to remember all her information?
Regarding the medication?
In order to determine what that medication was?
She never told me the name of the medication, no.
Okay. And when someone is pulled over and a DWI investigation is conducted, who determines if the field sobriety test, alternatives, or a preliminary breath test is necessary?
Objection, irrelevant, and
So the objection was to relevance, is that right?
vagueness. When someone gets pulled over, who determines? Like in all cases?
Right. Mr. Richmond, a response?
Yes, Your Honor, we heard on the lapel video, the defendant state that you felt that it wasn't necessary. So I'm just asking the officer whose determination it is to make that decision.
I'll overrule the objection. He can answer the question.
Yeah. Officer, would you like me to repeat the question?
Yes, I'm sorry, if you could, please.
Yep. When someone's pulled over and a DWI investigation is conducted, who determines if the field sobriety test, alternatives, or a preliminary breath test is necessary?
The investigating officer.
All right, thank you, officer. No further questions for the purposes of this probable cause motion hearing.
Okay. All right. And Ms. Funk, is there any cross-examination?
Yes, one moment. Officer Herbst, you pulled over Ms. Montoya for speeding and following cars too closely, right?
Yes.
And you didn't use your radar at all to determine Ms. Montoya's actual speed, correct?
Correct.
Before you pulled Ms. Montoya over, you said she was weaving in and out of traffic, right?
Yes.
And there was heavy traffic at that time, correct?
Yes.
Objection, Your Honor.
What's the objection?
I was going to say on speculation of that there was no evidence or testimony regarding the type of traffic.
The objection's overruled. He was there, so he can tell us whether or not there was a lot of traffic. So Ms. Funk, please proceed.
And Ms. Montoya never hit anyone, right?
No, she did not.
She maneuvered around the cars and kept going forward, correct?
Yes.
Now, you testified on direct that Ms. Montoya had bloodshot eyes, isn't that correct?
Yes.
You even testified on direct that Ms. Montoya's bloodshot eyes formed part of the basis for your probable cause to arrest, correct?
Yes.
But when you pulled her over, Ms. Montoya's eyes were not bloodshot, were they?
I thought they were.
So, Mr. Herbst, you created a police report in this case,
Yes.
and that police report was contemporaneous, like right after the event,
Yes.
and it was when things were fresh in your memory.
I'm sorry?
It's when things were fresh in your memory from this event.
Yeah. Yes.
And would you lie on your police report?
No.
Would you misrepresent things that you thought were true?
No, I would not.
And isn't it true that on your police report, you put specifically that she did not have...
Objection, Your Honor. Facts not in evidence. Or the police
Funk,
report is not in
response?
evidence.
It's impeachment, Your Honor.
Yeah, this is for impeachment purposes. The objection's overruled.
Isn't it true, Mr. Herbst, that your police report specifically noted no bloodshot eyes?
I thought it did when I was reading it prior to the trial.
So you read it prior to the trial?
Yes, I did.
And when roughly did you read it?
Maybe an hour or so before the trial. So what's that, around 1 o'clock or so?
An hour before trial. And now you're testifying that she had bloodshot eyes and that your report also says she has bloodshot eyes?
From my recollection, yes.
All right. So, Your Honor, this time I'm going to share my screen so we can see Mr. Herbst's police report. Because it is impeachment.
So, counsel, that would be improper refreshment. If you want to refresh his memory with the report, you can ask him, and then I need to step to the side, okay?
Yes, but this is not for refreshing a recollection, Your Honor. This is for impeachment. So refreshing recollection, I cannot show you, but for impeachment, I can show the court and the fact finder.
I disagree, counsel. Reports are not taken into evidence and won't be considered. So if you want to refresh his memory with the report, you can show him the report. Let me know and I'll step to the side. But police reports cannot come into evidence, and I don't want to see that. That would taint this process. So you can show it to him. Just let me know and I'll step to the side. Okay.
Okay, so it's your ruling that for impeachment purposes, nothing outside the exhibit list can be shown to the fact finder. Is that your ruling?
Correct.
Okay. So yes, if you would step to the side. Oh, actually, Mr. Herbst, would looking at your police report refresh your memory as to whether or not you wrote that Ms. Montoya had bloodshot eyes?
Yes, it would.
Okay. And Your Honor, do I have permission to use the police report to refresh this witness's memory?
Yes, you do. And someone just shout out when it's no longer on the screen.
Officer Herbst, can you hear me? I'm sorry, I can't hear you. You cut out. Can you hear me?
Yes, I can.
Okay. And let's go to the top. Do you recognize this document?
Yes. Let me read it. Yes, I do.
Okay. Is this the police report regarding Ariana Montoya's arrest on the state?
Yes, it appears so.
Okay. And then if you keep scrolling, you see that this is the report that you did, and this is the narrative at the bottom.
Correct.
Okay. Now, if you look at line 18 and 19, I'm going to keep scrolling. Can you read that out loud for me?
If you could just scroll up a little bit where I put the bloodshot water guys, because there's an actual box for that.
Correct, but I'm not asking you for that. I'm asking you to read your narrative, and I'm asking you to read 18 and 19. Can you do
Right,
that?
but I do believe I put click the box for bloodshot water guys.
Yes. Can I have you read 18 and 19, because that has the information I want from you? I'm literally specifically asking you something about your police report.
Sure.
Can you read 18 and 19 for me, please?
I contacted the driver, Ariana Montoya, and immediately noticed her eyes were very watery, although not bloodshot.
Does that reflect your recollection about whether they were bloodshot?
Yes, I would still like to see the other box though. That would help me out.
But, okay. I think it was around here. Let's see. Have you seen the part you want to see?
Yes, I have. I did check the box that says bloodshot watery eyes.
Yes. And your narrative has reflected your recollection about your actual observations of her eyes, correct?
Yes, both of those have. Thank you.
All right, thank you. And we're ready for the court.
Okay, parties, please proceed with cross-examination.
Officer Herbst, has your memory been refreshed about your report?
Yes.
In the narrative section of your police report, in lines 18 to 19, did you not put that Miss Montoya had not bloodshot eyes? In the narrative
Correct.
section?
Yes, ma'am. I put there watery, not bloodshot.
Thank you. Okay. So you'd agree that there is a number of different things that can cause watery eyes, correct?
Yes,
For example, crying can cause watery eyes,
correct.
and allergies can also cause watery eyes,
Yes,
and irritants in the eye, such as old contacts, can cause watery eyes.
yes,
So you notice watery but not bloodshot eyes, and then you ask Ms. Montoya when she last drank alcohol, right?
yes, I did.
And she told you that she hadn't had anything to drink since the day prior, correct?
Yes,
Then you asked if she had taken any prescription medications, right?
yes, I did.
And she told you that she had taken medications for her anxiety and depression, right?
Correct.
She told you that the medication was new to her, correct?
Yes,
She told you that she doesn't usually take the medication, right?
right.
But that she'd taken her prescription on that day because she had a lot going on in her life at that time, right?
Correct.
And you testified on direct that PTSD and anxiety, which she had, you didn't think would affect her ability to do the Fields tests, right?
Well, she didn't ever mention anything that those would affect her ability to do the fields, but that's correct. I didn't either.
Okay, but you're not a doctor, right?
I'm not.
You have no medical training in PTSD or anxiety? Do you have medical
Training? No, I don't have medical training.
Okay, okay, thank you. And then you made her do the Fields test, correct?
Objection, Your Honor. To the phrasing, speculation that the officer made the defendant or do the fields.
I think the characterization's fine. The objection's overruled. Ms. Funk, please continue.
You then made her do the Fields test, correct?
He agreed to perform field sobriety testing.
So you asked her if she would perform it, or did you tell her that she would perform them?
I don't remember my exact wording, but I would not say that I made her perform field sobriety tests. No.
So you asked her if she would do them?
Like I said, I don't remember my exact wording, but I would not characterize that as making her perform the tests. No.
Okay, but you don't remember ever asking her to do it?
I don't recall my exact wording.
That's fine.
But she agreed.
I don't need your exact wording. I just need to know if it was a question or an order. Those are pretty basic.
I would not characterize it as making her perform field sobriety tests. No.
Okay. You didn't say she needed to step out so you could do a couple tests?
Yes, I asked her to step out.
Ms. Montoya complies when you order her to step out, correct?
Again, I wouldn't use that wording.
Okay, well, let's just refresh our memory so we're all on the same page and just watch the part of the exhibit that's already been entered as the state's Exhibit 1. And I'm just going to share my screen. And then I think it's right here. Okay. Oh, actually, apologies. I think I have to, I'm not sure if I shared the audio. There we go.
That's fine. Let me do this. Let me have you step out so you can do a couple tests so I can make sure you're safe to drive, okay?
Now, Officer Herbst, did you detect a question in there, an ask of her to do the test?
Yes, absolutely. That sounded like a question to me.
That sounded like a question to you?
Well, at the end I say okay, and based on that my voice inflection, that definitely sounded like a question to me.
Okay. So let's move on here. Ms. Montoya complies when you ask her to get out of the car, right?
Yes, she does.
And when she steps out of the car and walks with you, she's not stumbling or losing balance, right?
She did not.
Okay. And after you had Ms. Montoya step out of the vehicle, you started to conduct the field sobriety tests, right?
Yes.
Now, you were trained to do these field sobriety tests using the NHTSA DWI manual, right?
Correct.
And what makes these, let the record show that Officer Herbst's phone is ringing and he's leaving the area briefly to.
Counsel, his phone rang. He's getting the phone, and I'll let you start over with the question, okay?
Yeah, I'm just stating for the record.
All right, I put it on site.
What makes these tests, Officer Herbst? Let the record reflect.
Yes,
that
ma'am.
I can't see him moving. Can anyone else?
The screen is frozen.
Yeah, same for me. Oh, there he is.
Is it moving now?
We can see you now, officer.
And can you hear me okay? I'm not lagging in my voice.
No, everyone else was fine. I think it was just me.
Okay. So you were trained to do these field sobriety tests using the NHTSA DWI manual, right?
Correct.
And what makes these tests standardized is that they're supposed to be done the same way for everyone who takes them, right?
Correct.
And before doing the HGN test, you asked Ms. Montoya if she wore contacts, correct?
Yes.
The NHTSA DWI manual requires that you ask about glasses and contacts, right?
Yes.
And she told you that she had contacts in at the time, right?
Yes.
She also told you that these contacts were really old, right?
I don't recall if she said that.
Okay, so if I played the portion of the video for everyone that talks about the contacts, would that refresh your recollection as to what happened?
Yes, it would.
Okay, one moment here. I'm going to again play the State Exhibit 1. Apologies, 1 minute here.
Do you have any contacts in?
Yes, I do have contacts. Yes. And they're really old.
So Ms. Montoya told you that she had contacts in and they were old?
Yes, she did.
Okay. And you never asked Ms. Montoya if she wore colored contacts though, right?
No, I did not.
So you don't know if Ms. Montoya was wearing colored contacts that night, right?
Objection, Your Honor. Relevance.
So the
Okay.
objection is to relevance. And Ms. Funk, I need a proffer. Where are you going with this?
It's based on the NHTSA manual, specifically mentions colored contacts, Your Honor, and he was trained on the NHTSA manual and testified about it.
Okay. I'll allow the question, but frankly, the HGN, any results of that were excluded. So I'm not really sure how this is relevant. I'll give you some leeway to do something with it.
Yes, and I would just note that he was testifying about HGN, and so we're questioning about it, but not about the results. So you don't know if Ms. Montoya was wearing colored contacts that night, right?
I do not.
But you still conducted the HGN test while she was wearing the contacts she told you she had in,
Yes, I did.
and you still graded her on the test?
I wouldn't use the word grading necessarily.
You looked for signs of intoxication during this test?
Yes, standardized clues and ability to follow instructions. Yes.
And the NHTSA manual specifically says that colored contacts may affect the ability to judge this test, right?
It could. I'm not sure. If it does, I would take your word for it.
Okay. So during the instructional phase of the walk and turn, Ms. Montoya successfully got into the instructional position, right?
Yes, she did.
She never wobbled during this time?
She did wobble getting into the instructional position, but once she was in it, her feet never broke apart.
And she successfully maintained that heel to toe start, right?
Yes,
And she began the test when you told her to begin, right?
she did.
She correctly walked all 18 steps in a heel to toe fashion, right?
Yes,
She never stepped off the imaginary line either, right?
she did not.
She never stopped in the middle of the test either, correct?
Correct.
And she also took the appropriate number of steps.
She did.
Now, the NHTSA DWI manual stresses that the validity of the tests is only applicable if they are administered in a standardized way, right?
Correct.
The NHTSA manual itself says, if any one of the SFST elements is changed, the validity may be compromised, right?
Correct.
And throughout the NHTSA manual, the terms standardized instructions, standardized clues, and standardized criteria are mentioned a number of times, right?
Yes.
So it would be fair to say that the fact that the tests are standardized, meaning they're performed the same for everyone, that fact seems to be a major focus of the NHTSA manual, yeah?
Yes, it is.
And if you note a clue that's not on one of the standardized clues, that violates the rules of the standardized test, presumably, right?
No. Can you repeat that question?
If you know something is a clue, but it's not a clue in the NHTSA manual, that makes it not standardized then, right?
Well, I still understand that question. I mean, it either is a clue or it's not a clue. So if it's not a clue, I'm not going to count it as a clue.
Exactly. And so if it is a clue, it would be in the NHTSA manual, right?
All 8 clues for the walk and turn are described in the NHTSA manual.
Okay. Now, regarding the turn in the walk and turn test, when you describe the turn portion of the test, you never told Ms. Montoya which direction to turn, right?
Correct.
And you never told her which direction to turn because turning in a particular direction is not part of the NHTSA standardized walk and turn test, right?
Not part of the instructions, correct.
Okay. So if you marked Ms. Montoya off for turning in a particular direction, you would be noting a clue that is not actually a clue, according to NHTSA, right?
Correct. I did not do that, but that is correct.
So it's your testimony that you did not mark Ms. Montoya off on the test for turning to the right rather than to the left?
Well, she took 9 steps. So if you take your 9 steps, leave your front foot on the ground, take a series of steps turning yourself around, you would have to turn to your left.
Why is that the case?
Because
Yeah.
your left foot's forward. So to conduct a proper turn, that would be your right foot taking a series of steps and you would turn around to your left. The reason we don't say that is because we could induce a clue there. If they only take 8 steps and their right foot's forward, they could still do a proper turn by taking their left foot and turning to their right. That would still be a proper turn. But she took the correct number of steps, so turning to her right would be an improper turn.
So it's your testimony that based on the direction she turned, that determines whether the turn was proper or improper according to NHTSA.
It can based on the number of steps that she took, yes.
So you marked her off for turning to the right, correct?
To the right and no series of steps too, I believe.
But you marked her off for turning to the right, correct?
Yes, that and no series of steps, correct.
Perfect. That's what I want to know. Okay, even though the direction of the turn is not a clue that's stated in the NHTSA manual.
An improper turn is a clue, and that is an improper turn.
According to you, the direction matters.
I would say according to NHTSA, the direction matters as well. If you take 9 steps and turn to your right, that would absolutely be considered an improper turn.
Can you point to a place in the NHTSA manual where it says you have to turn to the left or to the right?
Well, I can point where it says improper turn, and that would be an improper turn.
So you get to decide what's improper, not NHTSA?
I believe anyone in NHTSA would say that's an improper turn as well.
So you can point me to a place in the manual where it says, if the person turns to the left or to the right, that's improper.
Objection, Your Honor. Asked and answered.
Counsel?
I don't think I got an actual answer to that. I think there's an explanation, but I don't think I got an answer to whether he could point to a place in the NHTSA manual.
He did answer that earlier. This is both argumentative and asked and answered. The objection is sustained. Ms. Funk, please move on.
You testified on direct that you didn't notice any physical impairment that would hinder Ms. Montoya's ability to do the fields tests, right?
Correct.
But you did note that Ms. Montoya was 5'3", right? In your report.
I think that was based on her driver's license, yes.
And you noted that she weighed 190 pounds?
According to her I just put her in her driver's license statistics.
Okay. So she's 5'3", 190 pounds, but you still had Ms. Montoya do the one leg stand test, right?
She did not appear 50 pounds or more.
That wasn't my question. My question was, you still had Ms. Montoya do the one leg stand test while noting that she was 5'3" and 190 pounds. Isn't that right?
Well, that's not right because I didn't type those into my report until after the arrest, and I just went off of her driver's license, and that was after the arrest. So during this fields, she didn't appear 50 pounds or more overweight. So I went off of my observations.
Okay, so it's your testimony that you did not think she was overweight.
Not 50 or more pounds overweight, correct?
Okay, but you do acknowledge that the NHTSA DWI manual specifically says that studies suggest that individuals who are overweight by 50 or more pounds may have difficulty performing this test, right? You acknowledge that?
Yes, I do.
Okay. And Ms. Montoya completed this test with her shoes off, right?
Yes.
Now, you noted on direct that Ms. Montoya started the one leg test too soon, right?
Yes.
But that's not one of the NHTSA clues of intoxication, is it?
It's not a standardized clue for the one leg stand.
After you completed your instructions, you asked if she had any, right?
Is she had any what now?
You asked if she had any questions, right?
Oh, yes. Yes, I did.
And in response, she started to move into the position while asking you to check and make sure she was doing it right, correct?
Yes, I remember she said she wanted to make sure that her foot was 6 inches, something like that.
Okay. And she actually waited until you told her to begin the test before starting it for the full time, right?
Well, I asked her to put her foot down, and then she did, and then she started again when I asked her to. Yes.
Okay. Now, when you were noting clues on this test, you noted a clue that actually flat out didn't happen, correct?
I don't think so. Can you explain?
So you marked Ms. Montoya off for putting her foot down during the test, right?
Oh, yes, she did put her foot down.
So let's actually watch that part of the exhibit.
You want me to hold these?
There's a sharp beeping sound. Does everyone else hear that?
Let's test. Okay, ma'am, go ahead and begin.
1, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 1009, 1010, 1011, 1012, 1013, 1014, 1015, 1016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025.
All right, ma'am, you can stop.
So, Officer Herbst, before you said
Yes.
all right, indicating she could stop, Did she put her foot down?
Yes, she did.
What time was that?
It was within the first 5 seconds. So the video, when you share it, it's very choppy. I watched it on my computer before trial, and I saw her. It confirmed that she did put her right foot down sometime within those first 5 seconds.
All right, so let's watch that one more time because I don't see what you're seeing, and I think that's a problem. All right, let's go back here. All righty.
Yeah, 1001, 1002, 1003, and then just keep counting in that manner, not sequential manner until I tell you to stop. All right, any other questions? Do you understand the test? Okay, ma'am, go ahead and begin.
1, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 1009, 1010, 1011.
So it's your testimony she put her foot down?
Yes, she did. And again, it's very choppy from my end to put it on an exact second. But I remember when I watched the video prior on my computer, it was within the first 5 seconds.
Okay. And you also marked her off for swaying during the test, right?
Yes. Yes, I did.
And the DWI manual, the NHTSA manual, specifically says slight tremors of the foot or body should not be interpreted as swaying, right?
Correct.
Okay. So let's watch the one leg stand. And I want you to say stop or to note the time in the lower left hand where you're telling us that she swayed more than just a slight tremor of the foot or the body, okay? You testified on direct that she swayed on 2 separate occasions. So please note
Yes.
both times, and we'll go through it, and I want you to tell me the timestamp where you're saying that she swayed more than a slight tremor.
So like I said, it's very choppy, and there's also a lag when I watch these videos. So it probably isn't, it's not going to be able to work based on that. I could do it on my work computer, which is the exact same video, and I could tell you, but just by watching this one, I couldn't do it because it's so choppy and laggy.
Okay. Your Honor, can I have a minute to speak with co-counsel?
Yeah, do you mind just trying to play it for me? Do you mind just taking a stab at it, regardless of the chop, for him to see if he can?
Okay, it sounds like the officer's telling me he can't, but Officer Herbst, do you want to take a stab at it as the court has requested?
I actually do remember roughly when she swayed. The first one was in the first 5 seconds, and I believe the second one was around 15 seconds in. And that was, that's my recollection.
All right, can I have a moment to speak with co-counsel, please?
Sure.
Thank you. Your Honor, we can move on.
Oh, okay.
So after the Fields test, you asked Montoya. Sorry, I'm getting some feedback here. Am I the only one?
That too.
Oh, I'm not.
All right, let's try again. After the Fields tests, you asked Ms. Montoya to submit to a preliminary breath test, right?
Yes.
Do you ask everyone to stop to complete a preliminary breath test after they complete the Fields?
No.
Ms. Montoya told you that she did not think a preliminary breath test was necessary, right?
Yes.
And she initially declined to take the preliminary breath test, right?
Yes,
You testified on direct that it was pretty clear that she didn't want to complete the preliminary breath test, correct?
correct.
But then a few seconds later, she asked you if she could take the preliminary breath test, right?
After I told her she was under arrest, she did, yes.
And that was just a few seconds later, right?
Right, but telling her she's under arrest changes things.
So that means she doesn't get a chance to take the preliminary breath test?
Well, if she's under arrest, no, the PBT comes before arrest, and I told her she was under arrest, so.
Okay. So even if it's a few seconds later, that's the line.
Because me telling her she's under arrest changes everything.
Okay. And even though she requested the opportunity to blow, you told her that she could not, correct?
Right, correct.
You told her, quote, "That's over and done with. You lose that chance," right?
Correct.
You never offered Ms. Montoya the opportunity to complete any alternate fields test, did you?
No, I never asked her to perform alternative sobriety testing.
Even though she was overweight, you only completed the 3 standardized fields tests, correct?
Yeah, did not appear more than 50. So,
And even though she had said that she was taking medications for underlying diagnoses, you didn't give her the chance to do the alternative fields tests, right?
correct. No alternative field sobriety testing.
Now, you never saw Ms. Montoya drinking anything on the day of the incident, right?
I did not.
You never opened the small bottle of liquid that you allegedly found in her vehicle?
I did not open that bottle.
You just saw some clear liquid in that bottle, right?
Correct.
You never smelled that liquid?
No, I did not.
You never tasted that liquid?
Did not.
You never had that liquid tested to determine what it was?
Correct.
Defense passes the witness.
Mr. Richmond, is there any redirect examination?
Yes, briefly, Your Honor. Now, Officer Herbst, after you observed or after you saw your police report, did you check a box that said the defendant had bloodshot watery eyes?
Yes, I did.
Now, although there are many things as was said on cross, I think cause bloodshot watery eyes, is that an indicator of impairment?
Yes, it can be.
Is that also the case with watery eyes?
Yes.
Did the defendant say if her PTSD, depression, or her anxiety would affect her performance on the standardized test?
No, she didn't.
Did you force the defendant to take the standardized tests?
No.
Did the defendant agree to perform those tests?
Yes.
On cross-examination, were you asked about the defendant's eyes?
Yes.
Were you asked about the defendant's contacts?
Yes.
Were you asked if those contacts would affect the results of those tests?
Are you asking if on cross I was asked if her contacts affected the results of the test?
Yes.
I can't remember if she asked that specifically. I'm sorry.
Yeah. And what does HGN test?
Reaction to the HGN evidence.
Your Honor, the defense.
Okay, go ahead. What's the relevance of this question?
Oh, I'm sorry, Your Honor. I was going to argue that the defense opened the door to eye movement by their questions on cross, by asking about eye movement contacts, if the contacts affect HGN.
Okay. Well, I think that's a colorable argument. Ms. Funk certainly did get close to opening the door there. It was very curious to me. I am going to maintain my prior ruling that I've made since the beginning. Any reference to eye movement is excluded from trial and in this hearing. Please move on, Mr. Richmond.
Yes, Your Honor. Yeah. And Officer Herbst, on the walk and turn, is the defendant to take a specific number of steps?
Yes.
And how many steps?
9 steps down and then 9 steps back.
And if the defendant takes 9 steps, would that affect the turn?
Yes.
Does it, based on what foot is in the front? Does it matter what direction the defendant turns on the walk and turn?
Yes, it does. To be a correct turn, it does.
And does it matter if the defendant completes proper turn?
Yes, it is a standardized clue.
And did the defendant complete a proper turn?
She did not.
Okay. And did you weigh the defendant?
I did not.
Did you measure the defendant?
No,
Did the defendant say that she couldn't complete the one leg stand?
no,
Did the defendant ever say that she couldn't complete the one leg stand due to her height or weight?
no.
All right. And Your Honor, I'm going to share my screen just briefly regarding the clue defense asked about regarding the defendant putting her foot down. If you can just give me one moment.
And Your Honor, before a screen is shared, I would ask the state clarify more than just the screen what they're actually going to be showing.
Your Honor, the exhibit 1 is in evidence and it will be the one leg stand, which has already been played. I'm just trying to clear, or it's an item that's brought up.
The state can play State's Exhibit 1.
All right, and Officer Herbst, give me 1 second to find the.
Okay, go ahead and begin.
All right, and Officer Herbst, do you see the defendant's foot right now?
Yes.
Now, is that foot in the air or is it on the ground?
Hold on, let me turn my phone a little bit. It looks like it's in the air there.
All right.
Yeah.
1,000.
And Officer Herbst, at this point, is the defendant's foot on the ground or is it in the air?
On the ground.
Thank you. Give me 1 second. And why did you ask the defendant to take a preliminary breath test? Excuse me.
I asked her because of her admission to taking an anti-anxiety medication. I wanted to see if her poor performance on the tests was more due to the alcohol I was smelling or the drugs she had taken, or both. The PBT could assist me with that.
And are you obligated to offer the defendant a preliminary breath test?
No.
And when did the defendant ask to take the preliminary breath test?
She said she'd be willing to take it after I told her she was under arrest for DWI.
And after the defendant is arrested, which is, or let me rephrase, excuse me. After an individual is arrested for DWI, are they later given a chance to take a breath test?
Yes.
All right, no further questions. Thank you, Officer Herbst.
Thank you, Counsel. Okay, and so that should conclude the testimony from Officer Herbst, at least for this probable cause motion. So Officer Herbst, you can hang up for a while we hear arguments. Depending on the ruling of the motion, the DA may call you to come testify further, okay?
Yes, sir. Thank you.
Okay, thank you. Okay, and State, do you have any additional testimony or evidence to present with regards to the motion?
No, Your Honor.
Okay, defense, do you have any testimony or evidence to present with regards to the motion?
Nothing, Your Honor.
Okay, we'll hear argument then. Because defense is the moving party, I'll hear first from defense.
Your Honor, all evidence subsequent to arrest should be suppressed here because given the totality of the circumstances, the officers did not have sufficient probable cause to arrest Ms. Montoya for driving under the influence. As explained in State versus Granillo Macias, 2008 NMCA 021, an officer has probable cause to arrest when the facts and circumstances within the officer's knowledge are sufficient to warrant an officer to believe that an offense has been or is being committed. Importantly, New Mexico law requires that probable cause be based on substantial evidence, according to State versus Cordova, 1989 NMSC 083. The New Mexico Constitution provides individuals with greater protection than with seizures or against seizures than the protection granted by the Fourth Amendment, as emphasized in State versus Rodarte 2005 NMCA 141. The facts here do not rise to the level of probable cause, as there is not substantial evidence that Ms. Montoya drove while intoxicated or that she knowingly drank. First, the DWI evidence compiled against Ms. Montoya is substantially less than other cases where New Mexico courts have found probable cause to arrest for DWI. For example, in State versus Granillo Macias, the New Mexico Court of Appeals found probable cause for DWI where the defendant failed to maintain his position during the walk and turn instructional phase. He missed heel to toe steps multiple times. He raised his arms multiple times, stopped during the test, and turned incorrectly. The defendant also swayed heavily during the one-leg stand and only raised his foot an inch off the ground. In stark contrast, Ms. Montoya never slurred her speech. She did not have bloodshot eyes, and she maintained control of her body as she exited her vehicle, walked with the officer to the sidewalk, and took off her shoes and began the fields tests. She answered questions and engaged in dialogue with the officer in an alert and intelligent manner, and she asked intelligent clarification questions. During the walk and turn test, she successfully maintained the instructional position, completed all walk and turn steps, walking heel to toe. She began the test after being instructed to do so. She never stepped off this imaginary line, and she never stopped in the middle of the test. She took the proper number of steps and never lifted her lead foot when she made the turn. She completed the test nearly perfectly. For the one-leg stand, she completed it nearly perfectly as well, even though she was overweight, and the NHTSA DWI manual specifically says that this can impair a person's ability to pass the test. Ms. Montoya stood sturdy on one leg, remaining almost entirely still for the full duration of the test. She counted correctly and placed her foot high enough. Moreover, she requested to take the preliminary breath test, and the officer refused to give it to her, saying that she lost the chance, even though he had just asked her a few seconds prior. And she wasn't even offered any alternative fields tests. When you look at the facts in cases like State versus Granillo Macias, where probable cause was found, and then you compare them to Ms. Montoya's case, it becomes clear that there just is not enough to find probable cause for DWI here. Second, the officer displayed so many scoring errors when evaluating the fields test that his conclusion simply cannot be relied upon. The officer completed the HGN test without asking Ms. Montoya if she wore colored contact lenses, even though the NHTSA DWI manual says that colored contacts can affect this test. And Ms. Montoya told the officer that she had contacts in. The officer improperly marked Ms. Montoya off for turning to the right during the walk and turn, when that is not a clue recognized by NHTSA. He could not point to a single place in the manual that says that turning is a clue. He also scored the one-leg test, even though Ms. Montoya was substantially overweight, and the DWI manual cautions against giving this test to someone who is overweight for their difficulty in completing it. He later marked Ms. Montoya off for swaying during the one-leg stand, but the video showed her remaining almost completely still and unmoving. And the NHTSA manual said slight tremors are not clues, it's actual swaying. And I would encourage the fact finder to go back and look at that video for something that's not more than just a slight tremor, because on direct, the officer said it happened twice, and the video shows 0 times that this occurred. Ms. Montoya's completion of the test was nearly perfect, which is why the officer asked her to complete a preliminary breath test. Defense submits. And Ms. Montoya was not even allowed to take it, even though she actively requested to take it merely seconds after saying that she thought it was unnecessary. The officer wrongly deprived her of the chance to take that breath test. Ms. Montoya's actions are simply not the actions of someone who is intoxicated. There was no probable cause to arrest her, and the court must accordingly suppress all evidence after she was arrested, according to Sun Juan versus US, the US Supreme Court case applying the exclusionary rule to the fruits of illegal police misconduct. Thank you.
Thank you, counsel. And Mr. Richmond.
Yes, Your Honor. Probable cause exists when the facts and circumstances as observed by the officer through their senses are sufficient to warrant an officer of reasonable caution to believe that offense is occurring. And this is an objective standard. and probable cause requires more than a suspicion but less than a certainty. And the reasonable officer must have information to believe that criminal conduct probably exists, not that it positively exists. And like the defense said in State versus Granillo Macias, in that case, the officer's smell of alcohol from a defendant, combined with their lack of balance and poor performance on the field sobriety test, can create probable cause. And the defendant's admission to drinking prior to driving, combined with other factors, can also give an officer probable cause to make an arrest. So based off that, an officer does have probable cause when the facts and circumstances within that officer's knowledge are sufficient to warrant an officer of reasonable caution to believe that an offense is being committed or has been committed. In determining whether an offense is being committed, the officer can consider what they observe through any of their senses. And here, Your Honor, the facts and circumstances within Officer Herbst's knowledge were sufficient to warrant an officer of reasonable caution to believe that the defendant was committing or had committed the offense of DWI. And those facts and circumstances were first regarding the defendant's poor driving. The defendant was driving at a high rate of speed and was so high that Officer Herbst was unable to pace the vehicle. The defendant was tailgating, going over the speed limit in a 35, began swerving in and out of traffic, increased her speed, tailgated another vehicle, then changed lanes, and then accelerated to at least 60 miles per hour while in 35 mile per hour zone. And at that time, the defendant was still creating distance between her car and the officers. Then we heard the defendant's explanation that she thought she was going the speed limit, even though she was going at least 25 miles per hour over that speed limit, and she thought it was the other cars that slowed down. And that shows that the defendant acknowledged that she was going faster than those other cars, and Officer Herbst was only able to catch up to the defendant due to the slow traffic. Then we heard testimony regarding the interaction, that the defendant had bloodshot, watery eyes, the odor of lotion, along with a moderate odor of alcohol that Officer Herbst was able to observe through his mask while the defendant was in her car. And although the defendant did deny drinking that day, the defendant did admit to taking an unknown prescription medication that was new to her and was one that she normally did not take. And the defendant did say she had recently just taken it at around 7:30 and 7:45 p.m. And Officer Herbst contacted the defendant only about 30 to 45 minutes after the defendant said she took that new medication. And when asked what the name of that medicine was, the defendant couldn't provide that name, only saying that it was the generic one, but couldn't say what it was the generic one of. And when she went to look it up in her phone, we saw the defendant also forget her user ID. And once she was outside the vehicle, Officer Herbst, and still with his mask on, observed what was previously the moderate odor of alcohol when the defendant was inside her car now become stronger and persist throughout the duration of his interaction with the defendant. And then on the field sobriety test, when we saw on the walk and turn, on both sets of 9 steps, the defendant raised her arms more than 6 inches from her sides. And the defendant conducted an improper turn as she didn't take a series of small steps. As we heard Officer Herbst testify to, it would matter the way that the defendant turned in order to take a proper turn. On the one leg stand, as we saw, the defendant sway, put her foot down within a couple seconds after just starting the test and raise her arms. And we also saw the defendant start the test too soon. And after the one leg stand, Officer Herbst gave the defendant a couple chances to take the preliminary breath test to rule out the presence of alcohol, to which the defendant denied to take the test because she felt that it wasn't necessary. And the defendant also said she didn't have to drive and that someone else could come get her car. And it was only after the defendant was arrested that she now wanted to take the preliminary breath test. Those were the facts and circumstances within Officer Herbst's knowledge. So we have the poor driving, with the tailgating, the speeding, and the swerving in and out of traffic, the bloodshot, watery eyes, the moderate odor of alcohol with the smell of lotion while the defendant was inside her car. But once she got outside of her car, that odor of alcohol becomes stronger and persists throughout the entire interaction. The defendant's submission to taking an unknown new prescription medication 30 to 45 minutes prior to contact with the officer, the defendant's inability to remember her user ID, and inability to say what that medicine was a generic one of, the defendant's poor performance on each of the standardized tests, and then the defendant's refusal to take that Officer Herbst offered so he could rule out the presence of alcohol, along with the defendant's accompanying statements as to why she didn't want to take that test. Your Honor, these facts and circumstances were the ones that were within Officer Herbst's knowledge and ones that would lead an officer of reasonable caution to believe that the offense of DWI had been or was being committed. Thank you.
Thank you, Counsel. Ms. Funk, is there any reply?
1 minute, Your Honor. Nothing. to adjourn.
Okay, so parties, what I'm going to do is I'm going to, Andrea got a physical copy of State's Exhibit 1. I'm going to take a look at it. I'm interested in rewatching those field sobriety tests again. And then I want to go over my notes and I want to take a glance at the Granillo Macias case once more. So let's reconvene at 4:15 and I'll give a ruling on the motion. Thank you.
Thank you, Your Honor.
Okay, parties, let's go back on the record in State of New Mexico versus Ariana Montoya, T4DW 2020-1200. I see all of the attorneys are present. And Ms. Montoya, I see your name there. Can you just turn back your camera back on?
Ms. Montoya, can you hear me?
There we go. Okay. Okay, so parties, with regards to the probable cause motion, in the event where defense files a motion to suppress due to lack of probable cause to arrest, the court hears testimony and must determine whether the facts and circumstances within the officer's knowledge are sufficient to warrant an officer of reasonable caution to believe that an offense is being committed or has been committed. That standard comes from State v. Sanchez, 2001 NMCA 109. In reaching the decision today, the court has reviewed the testimony of APD Officer Zachary Herbst, State's Exhibit 1. The court also took an opportunity to review the Granillo Macias case cited by defense in argument, and the court will find as follows. The testimony in this case indicates that on August 14th, Officer Herbst was patrolling around Montano in San Mateo. He observed the defendant driving eastbound Montano at a high rate of speed. He observed her swerving lanes and following other vehicles too closely, at least 2 times. The officer testified that he followed her, he pursued her, and saw that he was driving 60 miles per hour and could not catch her. Eventually, the vehicle came to a stop at a stoplight. They then engaged in a stop. That leads to the officer's interaction with the defendant in this case. The officer observed an odor of alcohol as well as a fruity odor in the vehicle, and then later testified that he isolated the smell of alcohol, smelled it on her person when she was outside of the vehicle. The officer testified that he observed bloodshot watery eyes or watery eyes based on 2 different notations in the report. The court's really not able to observe anything in the video to that effect, so I don't place much weight there. The defendant denied consuming any alcohol and did not demonstrate any slurred speech. However, the defendant indicated that she had taken an unknown prescription for anti-anxiety or anti-depression purposes. The officer then performed the field sobriety tests. With regards to the first being the horizontal gaze nystagmus test, there was no legally admissible testimony about any problems with the horizontal gaze nystagmus test or any observations made during that. The officer then moved to the walk and turn test. With regards to the walk and turn test, the officer testified to observing 2 clues that the defendant's arms were raised and that the turn was incorrect. There was some dispute about whether the turn was incorrect with regards to the direction that she turned, but the court observed both the officer's instructions and then what the defendant did on the test, and the court's observation is that the turn was done incorrectly. It was not done with short, choppy steps. However, there were only 2 clues out of a potential 8. Then we moved to the one-leg stand. With regards to the one-leg stand, the officer testified that there were 4 potential clues and that he observed 3 of those clues. With regard to the foot going down, the court is able to observe early on in the test that the foot went down. The court was also able to observe numerous balance problems, a sway, and that the defendant's arms were raised. She had asked a number of clarifying questions, so I don't really note that she started early. I think she was just clarifying those things. And so parties, in considering the totality of the evidence, it's at that point that the officer offered the preliminary breath test. The defendant refused to take it. The officer decided to arrest, and then she asked to take it, and then the officer refused to take it. Frankly, the breath test at that point in time really doesn't weigh on the court's decision one way or the other. There's nothing required about taking the test. There was no implied consent act read at that point in time. It was an offer. She didn't want to take it. Then she did. And at that point, he didn't want to do it. I really don't read any inference of guilt in the refusal to take it. I just am not considering it in reaching my decision. What I am considering in my decision, however, is primarily the driving observed by the officer. the admission to taking some unknown pill, the odor of alcohol, and a mixed performance on the field sobriety tests. There were some good things and there were some bad things about the field sobriety test. All of those things taken together, I do find that the officer had probable cause to perform the arrest at that point in time. So I will deny the defendant's motion to suppress any evidence obtained after the arrest. And so parties, that leads us then to the trial portion of the case. And last week, private counsel Naomi Salazar was here and I made the offer. In an ideal world, we would hear these motions well before the case gets to trial to allow the parties to engage in continued negotiations. Based on that ruling, I made the offer to Naomi Salazar, who took Mr. Richmond up at least on the offer to discuss a plea. If you guys would like that chance, I can take a break to give you that chance. If not, we can proceed to trial, but I will make that exception given that we're doing a substantive motion on the day of trial.
Ms. Montoya, would you like to discuss with us? Not on the record, but would you like us
Do you
to
want a
call-
breakout room?
Yes, please.
So just to make sure I'm clarifying, you're
Ms.
saying that another plea had,
Let's go to a
I'm sorry?
breakout room. We'll go to a breakout room if you wait. Sorry, 1 minute.
Oh, okay, I apologize.
It's
You can
okay.
put what you need
And so
then-
Nick,
I
if you
will-
could put Ms. Funk, Ms. Montoya, and Mr. Wexler into a breakout room for a few minutes. And if you guys just want to shout out to Nick and he'll just give me a call, okay?
The court, could Nick potentially call the court back?
Yes.
Okay, parties, I see that everyone's back. Let's go back on the record. State of New Mexico versus Ariana Montoya, T4DW 2020-1200. And parties, where are we on the case?
Yes, Elise Funk on behalf of Ariana Montoya, along with Logan Wexler, and Ariana Montoya is present via video conference. We have discussed the case, Your Honor, and we will be proceeding with the trial at this time.
Okay. Okay, and with that, now we're at the trial phase. Mr. Richmond, does the state have any opening statement it would like to make at this point?
Other than the evidence that that has been presented, Your Honor, the state would just like to notify the court that we are proceeding on a per se theory.
Okay. Okay, and Ms. Funk or Mr. Wexler, any opening for defense?
Your Honor, in light of the evidence that's been brought out, we would just incorporate our initial probable cause opening.
Okay. And with that, Mr. Richmond, please call your witness.
Can you give me one moment to call the officer, sir? Please, thank you.
Yeah, it's okay.
And he will be logging on just in just a second.
Okay. Okay, welcome back, officer. And just for clarity of the record, we are here for trial now. I'm just going to swear you in again, okay?
Sir.
Could you please raise your right hand? Do you swear and affirm that the testimony you give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. With that, Mr. Richmond, your witness for direct examination.
Yes, thank you, Your Honor. And Officer Herbst, did you find anything in the defendant's car after the arrest?
Yes.
And what did you find?
So in her purse was there was a mini bottle of it appeared to be alcohol. That's what it looked like to me.
Was it empty or was it full?
It looked like it was mostly empty.
Could you tell if it was open or not?
It did appear to be open.
All right. And Your Honor, I will be playing a brief 30-second clip from State's Exhibit 1.
Okay.
Near enough.
Now, Officer Herbst, was that bottle that we just saw, was that the bottle you were referring to in your prior testimony?
Yes.
All right, thank you. And were any chemical tests offered to the defendant?
Yes.
What test?
It was a breath test through the Intoxilizer 8000.
And are you certified and trained to operate the Intoxilizer 8000?
Yes, and I was on that date as well.
And prior to August 14th of last year, about how many times had you operated the Intoxilizer?
Several hundred probably.
And was the Implied Consent Act communicated to the defendant?
Yes, it was.
How so?
There's a poster at our prisoner transport center that has the implied consent advisory, and I read it to Miss Montoya verbatim from that poster.
And did the defendant state that if she understood it?
Yes.
Was the defendant advised of her right to an independent test?
Yes.
Was the defendant advised that the arresting agency would pay for that independent test?
Yes.
And did the defendant agree to take the breath test?
Yes.
And how's breath alcohol content measured?
Grams of alcohol per 210 liters of breath.
And what kind of mouthpiece was the defendant given for the test?
It was a clean mouthpiece. It was factory sealed in plastic, and I had to open up that plastic.
And why did you give or a new mouthpiece?
Just in case there's any residual alcohol from an old mouthpiece, or it's contaminated if someone had touched it with hand sanitizer or something like that.
Was the defendant instructed on how to give a breath sample?
Yes.
What's the deprivation period?
A deprivation period is at least a 20-minute period where I ensure the person to provide the breath sample has nothing in their mouth, and then they don't have anything to eat, drink, or smoke for at least 20 minutes prior to giving a breath sample.
And was such a period conducted?
Yes.
And how did you ensure that a proper deprivation period was done?
I checked Miss Montoya's mouth and saw it was free from any foreign material. And I noted that time on my wristwatch, and she was in the back of my police vehicle the entire time, or until we got to the prisoner transport center. We walked up into the prisoner transport center. She was handcuffed the entire time, and so therefore there was no way she could have had anything to eat, drink, or smoke in at least over 20 minutes.
And was there anything in the backseat of your car that the defendant could have eat, drink, or smoke?
No.
And how do you know that?
I always check the back of my vehicle before every shift, and I make sure there's nothing back there.
And did the deprivation period start after you checked the defendant's mouth?
Yes.
And when did it end?
It ended 21 minutes after I checked her mouth, and I believe that was 9:02 p.m.
All right. And Your Honor, I will be playing on a few brief segments from State's Exhibit 1 in order to establish that timeline.
I need to make sure there's nothing in your mouth. Okay? Can you finish your mouth for me? Lift all the tongue there if you want. Thank you.
And Officer Herbst, was this when the deprivation period started?
Yes.
And do you see the time in the lapel video, or what timestamp this is at?
Yes, this is actually in a different time zone. But the minutes are actually the same as Mountain West time. Just the hours are different.
No, what do you mean by that?
Well, so this timestamp says 02 for the hours, 40 for the minutes, and 56 for the seconds. And that equated to New Mexico time as 8 p.m., 8:40 p.m. and 56 seconds.
All right, thank you, sir. And how about the timestamp on the lapel video, or how far into the lapel video?
Let's see. 20 minutes and 59 seconds.
All right, thank you. And let me fast forward to a different part of this lapel. Apologies, Your Honor. My computer's it's a little slow right now.
Is this plastic mouthpiece right here? You wrap the lips just around the end, making a tight seal, and blow out like robotic for balloon, okay? I'll tell you when to stop. It'll be about 6 seconds.
Yeah.
Go.
And Officer Herbst, do you see the timestamp on, or the time on the lapel video as to when this is right now?
This is 42:52.
And do you recall was this the first, or do you know which breast sample this was that is being shown right now? Judge Murphy, I think you're on mute.
There we go. Okay, sorry. I didn't hear anything. It looked like the officer was also on mute.
Oh yeah, I didn't hear an answer either. Officer Herbst, do you know which breath test this is right now?
That was probably the first breath test based on that timestamp.
All right, thank you, sir. Let me play one more. Oh. My apologies, Your Honor. I'm not quite sure what's going on. And Officer Herbst, given that this one is about 2 minutes later, do you know which breath sample this would be? Or
I would object at this point, Your Honor. I think there's some attempt to talk about the number of breath tests, but that's assuming a fact, not an evidence. And it's also vague as to which breath test this would be in the context.
Your Honor, this is to establish the timeline.
I'm going to overrule the objection. He can ask the question, but Mr. Richmond, you got to clean this up.
Okay.
This is,
Okay.
right. You're not making a very clean record, okay?
Yeah, my apologies, Your Honor. And Officer Herbst,
Did we lose him? And officer, if you could go ahead and unmute yourself.
Yes, sir.
Okay, Mr. Richmond, please proceed.
And Officer Hurst, do you know which sample that you just saw, that second one?
Objection as to vagueness, which sample?
I'm going to overrule the objection. I know what he's asking about the breath samples. He's clarified that there have been two, so I'll allow him to proceed. Mr. Richmond, please proceed.
Officer Herbst, do you know which breath sample was that? Was that second clip that we just saw?
Yes, that was the second breath sample.
All right, thank you, sir. Oh, sorry, Your Honor. Give me one. I'm going to reshare this just one more time briefly.
It's Ariana, right?
Yeah, I just need to get out as soon as possible just because of my son
Okay.
and his seizures. That's all.
Well, I'll let you make a phone call here in a second, at least to set something up. All right, Ariana, so listen to me. I'm about to tell you something important. You are under arrest for driving while under the influence of intoxicating liquor and/or drugs. The New Mexico Implied Consent Act requires you to submit to a breath test to determine the alcohol content of your blood. After you take our test, you have the right to choose an additional independent test. If you choose to take this additional independent test, you have the right to a reasonable opportunity to arrange for a physician, a licensed nurse, or a laboratory technician or technologist who is employed by a hospital or physician of your own choice to perform an additional chemical test. The cost of this additional test will be paid for by the law enforcement agency. Do you agree to take our test?
So you're asking me if I agree to take a breathalyzer test?
Yes.
Yes.
And Officer Herbst, was the Intoxilizer 8000 used on the date of incident certified by the Scientific Laboratory Division?
Yes.
How do you know that?
There's a sticker on the machine that has a serial number, and I matched that up to the serial number that's actually on the machine. Those numbers matched, and it said that the Intoxilizer with that serial number is certified by Scientific Laboratory Division, and it also gave a range of dates for when the certification begins and ends, and it was within those dates, meaning it was certified on the date in question.
Okay. And what did you do after turning on the Intoxilizer 8000?
I saw that it was working properly, went through its function check, and I entered Ms. Montoya's information into the logbook. And then when it passed a calibration check and it came time to provide a breath sample, I allowed her to provide a breath sample into the machine.
And was a diagnostic check done?
Yes, I'm sorry. That's what I meant to say. A diagnostic check was done, and it did pass the diagnostic check.
Can you explain a little bit about what a diagnostic check is?
A diagnostic check is just a pass-fail check when the machine is first turned on, and it shows if it fails, the machine is not working properly. If it passes, it indicates the Intoxilizer 8000 is working properly.
Yeah. And what's an air blank?
An air blank is when the machine sucks in fresh air through the hose, and the purpose of that is to get rid of any residual mouth alcohol which may be left in the machine from the prior breath sample.
And did the Intoxilizer run the required air blanks during the defendant's test?
Yes. Yes, it did.
And did the machine run a calibration check?
Yes, it did.
And was the calibration check within regulation?
Yes.
And did the Intoxilizer appear to be working properly?
Yes.
And how would you know if it wasn't working properly?
There's a screen on the machine, and it would say error and give the type of error, and it wouldn't let any breath sample be introduced if it was not working properly.
Based on your training and experience, Was there any indication that the machine wasn't working properly on the date of incident?
No, it appeared to be working properly.
Were you able to successfully collect the 2 required samples from the defendant?
Yes,
And was a record of those test results made?
yes.
And Your Honor, may I briefly share my screen in order for the foundation for the breath report to be laid?
Yeah, go ahead.
Thank you, Your Honor. Right. And Officer Herbst, I'm showing you what's been marked as State's Exhibit number 2. Do you recognize it?
Yes, I do.
And without saying the results, what is it?
This is what is commonly referred to as a breath card. It's the piece of paper printed out from the Intoxilizer 8000 that shows the results of Miss Montoya's breath samples. And I'm sorry, if you could just scroll down a little bit, just so I could see my signature.
Give me 1 second.
Okay.
What's the test date?
August 14th, 2020.
And who's the test subject?
Ariana Montoya.
And is there a signature on this card?
Yes, that is my signature.
And is this breath card in the same or substantially similar condition as when the test was performed?
Yes.
And have their results been altered in any way?
No.
Your Honor, the state moves to admit State's Exhibit number 2 in evidence.
In defense.
I would object at this point as one of the foundation elements has not been laid regarding calibration.
Okay, would you like to voir dire the officer with regards to that?
I would.
And Your Honor, if I may just respond briefly.
Okay.
Officer Herbst did testify that the calibration check passed.
I'm just going to give Ms. Funk a brief moment to voir dire the witness before I make my ruling on admission of this exhibit. Ms. Funk?
Your Honor, would you like me to, would you like me to stop sharing my screen in the meantime?
Sure, that would be helpful. It's easier if I see you guys bigger.
Yes, Your Honor.
Okay.
Officer Herbst, when was the last time that the machine had a calibration test done? Before the, apologies, withdrawn. Before the date of the incident, when you conducted the breathalyzer on Miss Montoya, before that date, when was the last time that a machine calibration test had been done on that machine?
Whenever another breath sample is introduced, it always does a calibration check then.
It does, you can't testify to when that was done?
To the prior time, no, I don't know when the last breath sample was given, but it does every time a breath sample is given, it does a calibration check.
Okay, so you have no way of knowing when that prior calibration would have been?
Objection, Your Honor. Relevance as to calibration checks for prior breath samples.
Okay, Ms. Funk?
I would just note that Bransford versus State versus Tax and Revenue Department says that it must have been showed that it was properly calibrated within 7 days. So and the person must be knowledgeable about the testing procedures and the manner in which the report was complied. So it's my understanding that these calibration checks happen once every 7 days if the machine is told to be working properly.
Okay, I'll allow the question if the officer knows the answer.
No, I don't remember when the last breath sample was given. That machine's used pretty often. As to the exact date, no, I can't recall that.
And so your testimony is that you actually calibrated it on that day?
It went through a calibration check.
Right. And isn't the calibration check to see if it's working properly, but that's not actually when it was calibrated. It's not calibrating at that time, right?
Yes, it is. That is a calibration check, and it shows it's within range.
Okay. And so the calibration check is the same as it being calibrated?
No, but the check shows that it was calibrated within the range.
Okay. And you can't testify that it was actually calibrated within a certain amount of time. You don't know when it was calibrated before the test was taken by Ms. Montoya, right?
It was calibrated on that date. As to the time before, I don't know.
One moment, Your Honor. Nothing further, Your Honor, and we would just oppose the admission on the basis that the machine that Officer Herbst testified that there's a calibration check done, but that's different than it actually being calibrated. And pursuant to Bransford 1998 NMCA 077, paragraph 10, the officer should show that it was actually calibrated within 7 days, not a calibration check done during the breathalyzer. So we would argue that there has not been sufficient foundation here because the officer could not testify as to when it was last calibrated. And so we don't know that it was calibrated within the 7 days as required.
And Mr. Richmond, any response?
Yes, sir. Just as Officer Herbst did testify, the calibration check was done and it was passed. And regarding it being done within the last 7 days, the calibration check was done prior to the defendant's breath samples being entered.
Okay. Parties, based on Officer Herbst's testimony over objection, State's Exhibit 2 is admitted into evidence.
All right, thank you, Your Honor. And now, briefly, share my screen just one more time for just a few seconds. Alrighty. And Officer Herbst, are these the results from the defendant on August 14th of last year?
Yes.
And what are those results?
The first breath sample was a 0.09 grams of alcohol per 210 liters of breath, and the second breath sample was a 0.08 grams of alcohol per 210 liters of breath.
All right, thank you. And what is the per se limit in New Mexico?
0.08 grams of alcohol per 210 liters of breath.
And
What was the objection?
calls for legal conclusion. He just asked for the legal limit.
Okay, Mr. Richmond, any response?
Just that that's within the officer's knowledge.
I'll overrule the objection. The answer will stand. Mr. Richmond, please move on.
And no further questions. Thank you, officer.
Okay.
Thank you.
All right, and Ms. Funk, any cross-examination?
Yes. So officer, the deprivation period is important because substances in someone's mouth make the breathalyzer readings inaccurate, correct?
Yes.
And if a police radio or certain electronics are turned on in close proximity to the breathalyzer machines, this can also cause the breathalyzer machine to malfunction, right?
Yes.
And you do not know the error rate of this particular breathalyzer machine that Ms. Montoya used, right?
What do you mean by error rate?
You do not know the rate at which this machine produces any error readings or erroneous readings, correct? You do not know a rate.
I've never heard of a rate before, no.
Okay, one moment.
Okay.
So, Officer Herbst, you don't know how often this breathalyzer machine is wrong and by how much in all instances, right?
All I know it was certified by SLB on that date. That's all I can testify to.
Okay. And your testimony on direct was that the lapel video of the deprivation period and that time, that was not in the correct time zone?
Yeah, according to the Axon Taser, which is a company that makes the on-body recording device, uses a different time zone. I believe it's like 6 hours ahead.
So a time zone that's not in the US, presumably?
Yeah, I guess that's correct.
So all of your lapel videos are then 6 hours off,
Correct, they are.
and you never talked to anyone about fixing that?
They're all 6 hours off, not just mine.
So your testimony is that, to your knowledge, every single officer's lapel video is 6 hours off?
Correct, according to Mountain West Standard.
Relevance to the time zone.
I
And
mean,
Ms.
time and deprivation and like actually the time of incident are relevant to, driving and the conditions and just the accuracy and the authenticity of this video. And the officer brought it up in
Okay.
direct.
Yeah, I'll overrule the objection. He's testified that they were off by 6 hours. That's been established. Okay.
Nothing further.
Okay. Mr. Richmond, is there any redirect examination?
Yes, just briefly, Your Honor. Now, Officer Herbst, can you remind the court about how many times you've operated the Intoxilizer 8000?
Hundreds of times.
And based on using the Intoxilizer hundreds of times, was there any evidence of malfunction or anything of that sort when using it this time?
No, there was not.
And how long did the deprivation period last?
It was over 21 minutes.
Now, does the time zone that your lapel video is on, does that change the fact that the deprivation period conducted was over 20 minutes?
No, it does not.
Does it change the fact that the defendant had nothing to eat, drink, or smoke during the deprivation period?
No, it does not.
Good. No further questions.
Okay, thank you. Okay, and with that, may Officer Herbst be excused?
There's nothing further from this. Thank you, officer.
Okay,
Thanks.
great. Officer Herbst, thanks for your time. You are free to hang up and enjoy your day.
Thank you, sir.
Okay, and does the state have any additional testimony or evidence to present?
No, Your Honor.
Okay, does the state then rest?
Yes, Your Honor.
Okay, the state is rested. Defense, do you have a motion?
Yes, Your Honor, at this time, we move for a motion of directed verdict as to both counts. All of the evidence, even in the light most favorable to the state, could never lead a reasonable fact finder to find Ms. Montoya guilty beyond a reasonable doubt. Start first with the DWI. We acknowledge the letters and the numbers on the printout of the Intoxilizer, but those machines are prone to error, and they're prone to error in an amount that Officer Herbst could not give us any information on. He did not establish that the machine is accurate. He established that it is certified by the Scientific Laboratory Division of the Department of Health. But as to how much you can trust a number on the page, he had really nothing to say. I will point out for Your Honor that the 0.09 and the 0.08 are 0.01 different from one another. And 0.08 is also 0.01 away from being literally not guilty of a DWI and being a 0.07. So the only evidence we have in terms of how much we can trust this machine is based on, well, it's certified. And considering how inconsistent the breath score is with the field tests, in that she basically aced them, is that we would say that there's really no way to not hesitate in finding someone guilty beyond a reasonable doubt. And hesitation is the touchstone for reasonable doubt. It's really the key word in the jury instruction about reasonable doubt. As to open container, Ms. Montoya is charged with 66-8-138 subsection A. That statute reads, "No person shall knowingly drink any alcoholic beverage while in a motor vehicle upon any public highway within the state." That means that the state must prove that there was a person inside of a car on a highway, and that that person who was in the car put the alcohol in their mouth and then swallowed it. The evidence that they have produced to that effect is there was a mini Smirnoff bottle inside the car that she was also in. There's absolutely no evidence on the video nor in testimony of the following facts. That Miss Montoya drank it while she was in the car, that Miss Montoya was the one who drank it at all, that the contents of the bottle were in fact alcohol, that the vehicle was on a highway at the same time that the contents were being consumed, and that the contents of the bottle were even consumed by any person and not just dumped out. So the state's not remotely close to proving any part of this statute, let alone every element. And so we would ask for that the court direct this verdict out as well, not guilty.
Okay, thank you. Mr. Richmond, any response?
Yes, Your Honor. The burden of proof to survive directed verdict is that given all the evidence in the light most favorable to the non-moving party, so in the light most favorable to the state, that the state has shown at least a scintilla of evidence that the elements of the offense have been established. And this is a very low standard, Your Honor, lower than a preponderance of the evidence. And in other words, the state has to show a prima facie case. And in response to the defense's second argument regarding the open container, the officer testified that he found a mini bottle of Smirnoff in the defendant's purse, which was found in the defendant's car, and we saw the lapel video footage to this point. And last, regarding and to the defense's other motion regarding the DWI about the deprivation period and the intoxilizer, that element of the DWI was sufficed. We saw from the lapel video on the timestamps that the deprivation period lasted over 20 minutes. It was a little bit over 21 minutes, and that the defendant gave 2 breath samples of 0.09, 0.08. And also Officer Herbst himself testified that the deprivation period was conducted for 21 minutes and clarified any ambiguity as to the time on his lapel video. And there's no evidence that the intoxilizer 8000 was malfunctioning. And in fact, that the second breath score was 0.08, that the state doesn't see how that means that the machine was working improperly. And we heard Officer Herbst's testimony that it's hundreds of times of using the intoxilizer 8000, that there was no evidence of a malfunction, and that the intoxilizer 8000 did pass all the required checks, the diagnostic checks, the calibration check, and all the required amount of air blanks were passed. Thank you, Your Honor.
Okay, thank you, counsel. Mr. Wexler, any reply?
Yes, Your Honor. The state has basically, as to the open container, made my point for me, that this was an alcohol container that no one has ever testified when it was drunk and who drank it and where they were at. And by the plain meaning of the statute, subsection A, there is absolutely no evidence for it. There may have been other ways to charge this, but as to the crimes alleged in the complaint, is an easy not guilty for that one.
Okay. Okay, so parties at directed verdict, the court must decide whether or not the state has met the prima facie elements of all of the elements for the crimes charged. In the light most favorable to the state, I'll find and rule as follows. Regarding count 1, the DUI, after consulting the statute 668102 as well as jury instruction 14-4503, the state has met the prima facie elements that the defendant operated the motor vehicle and did so within 3 hours, having had a blood alcohol concentration of 0.08 or more, and that this happened in New Mexico on or about August 14th of 2020. I found sufficient foundation was laid for the breath card. The officer testified sufficiently about the reliability and that it was certified and calibrated appropriately. So I'm going to deny the motion as to count 1. As to count 2, it's charged under 668138 subsection A. The state never moved to amend, and frankly, that's just the facts don't comport with what that charge shows. Subsection A requires a showing that the person knowingly drank the alcoholic beverage while in the motor vehicle. I think, frankly, that's the wrong subsection for this case. So I will direct that verdict out and we'll move ahead on just count 1, the driving while intoxicated. And so with that, defense, does defense have any testimony or evidence to present?
Defense rests, Your Honor.
Okay, the defense now resting. Let's move to closing arguments. Mr. Richmond, any closing argument for the state?
Yes, Your Honor. So in order to prove DWI per se, the state must prove beyond a reasonable doubt that the defendant was operating a motor vehicle within the city of Albuquerque, County of Bernalillo, State of New Mexico, and then within 3 hours of driving, the defendant had a BAC of 0.08 or above due to alcohol consumed prior to or while driving. Your Honor, each of these elements were proven beyond a reasonable doubt by the evidence presented. Officer Herbst testified that he observed the defendant on Montgomery and San Mateo, and he also testified that when he stopped the car and contacted the defendant, she was the only one in the car, and that this stop was in the city of Albuquerque, County of Bernalillo, State of New Mexico. He also testified that the defendant had bloodshot, watery eyes, an odor of alcohol, and there was also an odor of lotion within the car. But once outside of the car, that odor of alcohol became stronger and was present throughout the entire interaction. And we also heard the defendant admit to taking an unknown prescription medication about 30 to 45 minutes prior to her contact with Officer Herbst. And this was a new one and a medication that the defendant normally didn't take, one that she was unable to provide the name of. And we also saw the defendant perform poorly in the field sobriety test and then refuse the chance to take a PBT to rule out any alcohol. And then last, which is the most relevant regarding the final element, excuse me, that within 3 hours of driving, that the defendant had a BAC of 0.08 or above due to alcohol consumed prior to or while driving. And in the lapel video and through Officer Herbst's testimony, the defendant did not drink anything after contacting the officer. As we saw, the defendant did not eat, drink, or smoke anything. She contacted the officer, got out of the car, performed the field sobriety test, and then was handcuffed and put in the back of the car and then brought to the substation to give the 2-breath test. And meaning the alcohol in her system had to have been due to drinking it prior to or while driving. And we saw on the lapel video that the proper deprivation period was conducted, that it's began at 20 minutes and 59 seconds in the lapel video, and it wasn't until 42 minutes and 55 seconds that the first breath sample was given, making that first breath sample given more than 20 minutes since the beginning of the deprivation period, proving that it survived or lasted for more than the required 20 minutes. And also proves that the breath score was well within the 3-hour time limit, as this was within the hour that the defendant was stopped. And we also heard Officer Herbst's testimony that the deprivation period lasted 21 minutes. And then as the breath card showed, the defendant gave 2 breath scores of 0.09, 0.08, and both of these scores are either at or above the per se limit of 0.08. So with the evidence presented today, Your Honor, it proves that beyond a reasonable doubt that the defendant was the one that was driving in the city of Albuquerque, County of Bernalillo, State of New Mexico, and did in fact give 2 breath scores, which are 0.09, 0.08, which were at or above the per se limit of 0.08 within 3 hours of driving due to alcohol consumed prior to or while driving. And the state respectfully requests that the court come to the only verdict that is supported by that evidence, and that is that the defendant is guilty of DWI. Thank you, Your Honor.
Thank you, counsel. And defense, any closing argument?
Yes. Your Honor, the bottom line of this whole case is that you cannot find that proof of DWI beyond a reasonable doubt has been reached, where the state's only witness is not credible, combined with the fact that Ms. Montoya's actions as recorded were a far cry from those of someone who is intoxicated. Requiring proof beyond a reasonable doubt means that any doubt, as long as it is reasonable, prevents the court from finding Ms. Montoya guilty of DWI. And here there are so many reasons to have reasonable doubt. First and most importantly is the unreliability of the state's only witness to Ms. Montoya's demeanor and fields tests. First off, he wrongly completed the HGN test without asking Ms. Montoya if she wore colored contact lenses. Then he erroneously marked Ms. Montoya off for turning to the right during the walk and turn, when that is not a clue recognized by NHTSA. He also scored the one-leg stand test, even though Ms. Montoya was substantially overweight, and the NHTSA manual cautions that being overweight can hinder a person's ability to complete this test. Then the officer noted that Ms. Montoya was allegedly started the one-leg stand test too soon, when that is not even a clue recognized by NHTSA. And moreover, she actually did not start too soon. A review of the evidence proves that she was just asking for confirmation that she was lifting her leg high enough before starting the actual test. Most egregiously, the officer marked Ms. Montoya off for putting her foot down on the one-leg stand, which, if you look at the video evidence, is not clear happened. He then marked her off for swaying during the one-leg stand, but the video also proves that didn't happen. The video shows Ms. Montoya remaining almost completely sturdy and unmoving the entire time. And small pivots, as we've seen in the NHTSA manual and as the officer testified to, don't constitute clues. Second, Ms. Montoya's actions when completing the fields test show more evidence of her sobriety than her drunkenness. Ms. Montoya never slurred her speech. She did not have bloodshot eyes. The officer specifically noted that in his police report, he specified that there was no bloodshot eyes, just watery. She allegedly had watery eyes, but she also told the officer that she had been having a rough few days and that she struggled with depression and anxiety. And dealing with depression and anxiety can lead to crying, which clearly produces watery eyes. Ms. Montoya also said that she had really old contacts, which can produce watery eyes, as the officer testified to. Ms. Montoya walked steadily while exiting her vehicle and quickly took her shoes off to complete the fields test without difficulty. She answered the officer's questions and engaged in alert and intelligent dialogue with the officer. During the walk and turn test, she successfully maintained the instructional position and walked heel to toe for the proper number of steps. She began the test only after being instructed to do so. She never stepped off the imaginary line, and she never stopped in the middle of the test. She never lifted her lead foot when she made the turn, and overall, she completed the test nearly perfectly. Then she completed the one-leg stand nearly perfectly as well, even though she was overweight, and even though the NHTSA DWI manual specifically says that that can impair a person's ability to pass this test. Ms. Montoya stood sturdy on one leg, remaining almost entirely still for the full duration of the test. She counted correctly and placed her foot high enough in the air, keeping both legs straight. Moreover, she requested to take the preliminary breath test, and the officer refused to give it to her, saying she had lost the chance, even though it was only seconds after she was initially offered that test. As for the breathalyzer reading, intoxilyzer machines have inaccurate readings for any one of a number of factors that the officer even testified to. The machines are subject to chemical and electronic issues. They can be inaccurate without producing error messages, and things like radio frequency and stomach issues can cause the readings to be erroneous. The state has not produced evidence about the error rate of this machine. And when Ms. Montoya's BAC reading was within 0.01 of being under the legal limit, and she does nearly perfectly on the fields, you simply can't trust the breath card's accuracy beyond a reasonable doubt. We would incorporate Attorney Wexler's arguments in directed verdict here to show that there is a 0.08, 0.09 difference in the breathalyzer card numbers. And that 0.01 differential, if you move that in the opposite direction, 0.08 to 0.07, that's under the legal limit. That's not a per se violation of DWI. Also, Ms. Montoya's driving cannot provide any weight to support an intoxication finding. The officer testified that Ms. Montoya was speeding, driving closely behind other vehicles, and weaving in and out of heavy traffic. Her ability to effectively do this without hitting anyone shows that her driving was not inhibited from alcohol. On the contrary, she demonstrated quick reflexes and the ability to possess good control of her vehicle, even when going quickly, changing lanes, and driving amidst heavy traffic. Bad driving is not DWI. Any type of bad driving or fast driving, that is not evidence that can be used to support a DWI finding. For all of these many reasons and all of these doubts, the court must find Ms. Montoya not guilty. There are so many more reasons to doubt that Ms. Montoya was intoxicated than to believe that she was intoxicated. And no reasonable fact finder would see that all of the evidence presented today and find proof beyond a reasonable doubt of DWI. Thank you.
Thank you, counsel. Mr. Richmond, is there any reply?
Just briefly, Your Honor. All of Officer Herbst's observations were corroborated by his lapel video, including his observations on the field sobriety test of all the clues on the walk and turn on the one-leg stand. And the evidence presented today does prove each of those elements of a DWI per se beyond a reasonable doubt. Regarding the driving in City of Albuquerque, County of Bernalillo, State of New Mexico, and that within 3 hours of that driving, the defendant had a BAC of 0.08 or above due to alcohol consumed prior to or while driving. And there's no evidence presented that suggests that the intoxilyzer was not working properly. It passed all its checks, and Officer Herbst testified there was no evidence of malfunction and that he's operated the intoxilyzer hundreds of times. And the fact that the defendant's second breath score was at the per se limit, Your Honor, that the state doesn't see how that means anything regarding the accuracy of the intoxilyzer. Thank you.
Okay, thank you, parties. So parties at trial, the burden is on the state to prove guilt beyond a reasonable doubt. Reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person to hesitate to act in the graver and more important affairs of life. The state, well, at this point, given that count 2 was directed out, that just leaves us with the 1 count of driving while under the influence of intoxicating liquor or drugs. The state indicated that it was proceeding on a per se theory, as in 0.08 or above. I've looked at the statute as well as jury instruction 14-4503. I'll incorporate the previous findings I made at the probable cause motion in reaching this verdict. I do find that the defendant operated the motor vehicle. She did so in Albuquerque on August 14th of 2020 at a high rate of speed, speeding over 60 miles per hour in a 35 mile per hour zone. She followed 2 cars too closely and swerved between multiple lanes. That gave rise to the stop in this case. And while there is some disagreement about the characterization of the field sobriety test, I did find sufficient enough evidence in the officer's interaction with the defendant to support that probable cause finding, specifically the odor of alcohol, the admission to taking some sort of unnamed pill, and then the performance on the field sobriety test. There were some good things and there were some bad things. I did find that sufficient for probable cause to arrest, which then leads us to the breath alcohol score. State's Exhibit 2 was admitted into evidence. And so with that, I do find that within 3 hours of driving, the defendant had an alcohol concentration of 8/100ths, 0.08 grams or more in 210 milliliters of breath, and that the alcohol concentration resulted from alcohol consumed before or while driving the vehicle. The breath score speaks for itself. It's 0.09, 0.08, and that meets the per se limit. I also find that this happened in New Mexico on about August 14th of 2020. With those findings, I do find the defendant guilty of 1 count of driving while under the influence of intoxicating liquor or drugs. And so parties, would you all be ready to move on to sentencing today?
The state is, Your Honor.
Yes, defense is ready.
Okay. So as to sentence in this case, Mr. Richmond, what is the state requesting?
Yes, Your Honor. Given that this is a true first offense, the state would be requesting the first offenders program with 12 months deferred, Your Honor.
Okay. Okay, and defense.
And we would ask, in light of the fact that it is a first and it was what we believe to be and what the court fact finder has determined a mixed field result, we would ask for 6 months of probation and deferred, and the rest we would stipulate to.
Okay. And Ms. Montoya, it's your day in court. Is there anything you'd like to say prior to sentencing?
No, thank you.
Okay. So parties, as to sentence in this case, I will defer sentence for 1 year. For 1 year of supervised probation. Ms. Montoya will be supervised and shall complete the first offenders program. Ms. Montoya, that means that you'll attend and complete the DWI school. You shall complete the drug and alcohol abuse screening program and complete any counseling or treatment recommended by that program. You shall attend a victim impact panel. You shall not possess or consume any alcohol or illegal drugs, and random testing is authorized over the next year to ensure your compliance. You shall obtain the ignition interlock license and have the ignition interlock device installed and operating on any vehicle that you drive. You shall complete 24 hours of community service. You shall not violate any local, state, or federal criminal laws. You shall follow all orders and conditions set by the probation officer. You shall pay all mandatory costs. I'll note that you are a client of the law office of the public defender, so I will waive the additional costs of probation. And so with that, Ms. Montoya, the clerk will give you a call tomorrow morning to explain when and how to check in with probation tomorrow. What's a good number for the clerk to give you a call?
505-814-9917.
Great. So Nick Sanders is the clerk. He'll give you a call when we finish up tomorrow morning's docket. So that way he can give you the number so you can check in with the probation office then. Yes, Ms. Funk.
Yes, Your Honor, apologies, but I was just wondering if the court would make on the record that after Ms. Montoya completed the first offender program, she could move the court for unsupervised. I know that Your Honor typically does that.
Counsel, I'm not going to do that in this case. Typically, that's the standard practice when someone enters into a plea and takes some responsibility for what happened. Based on my observations of Ms. Montoya during this trial, she's been distracted, talking with other people, and I'm concerned that she may need some additional help in this case. You can always file the motion. It's not going to be a when complete, shall convert. If you file a motion when she's done with the first offenders program, I'll consider it then. But at this point in time, I'm not really sure that that's appropriate in this case, given what I've observed, as well as the facts illustrated in this case that I've already made findings on. Normally, I do that for pleas and trials, you don't know. But I'll entertain the motion if filed.
Understood.
Okay. With that, parties, is there anything else to address before we break on this case?
Nothing else from the state, Your Honor.
In defense?
Nothing from defense.
Okay. Thank you all for your time. Court is adjourned in this matter.
Thank you, Your Honor.